You need original side option need to. But may I be permitted to mention one original side matter, although the officers are not here. But all
You can take your chance tomorrow also.
no,
Tomorrow
that is why I am saying, the matter was supposed to come today. It is not in the list today. There is no original side list also. But I am apprehending that if it comes tomorrow, there will be some problem as far as I am concerned.
Anyway, I'll be available tomorrow.
Tomorrow the court will be sitting.
Yes, I'll be available.
But if it comes,
Probably after 12 p.m. or something. Usually original side matters are taken up after 12 p.m. on Friday. So
yes.
I'll be available, so no problem. After 12 p.m.
So if I am not there, my lord, kindly remember my London junior would be there. But kindly give me 1 day's accommodation to me.
Okay.
Kindly remember.
My lord, I just mentioned one second appeal, my lord, connection application, my lord.
Application. Yes.
Application.
Application, yes.
May I be permitted to mention, my lord, I'm for the appellant insurance company, application for stay.
Yes.
Claim case, my lord,
Matters. Application for stay.
but really claim, my lord, very complicated circumstances.
Now, is it ready for hearing matter? So let it appear as to be mentioned.
Service code.
Yes.
Railway claim case, let matter appear for
Hearing as to be mentioned.
Your Lordship, I'm mentioning for application in connection with second appeal.
Yes.
May I permit to mention, my lord, one application in connection with 7 up.
Second appeal.
Second appeal.
What application?
My lord, application for section 5 and application for substitution of party.
Okay, give it, but section 5 sub copy up on the other side.
My lord.
Yes.
Madam, may I permitted to mention, while I'm mentioning for an application to withdraw the admissible award amount of the awarded amount.
No, regarding which matter? Claim case? Application?
Application.
Yes, give it.
Your Lordship, may I be permitted to mention for inclusion of two matters, motor accident case, my lord.
Okay, to be mentioned. Yes, call the list. Now 10:30 fixed matter আছে তো একটা হ্যাঁ টু মেনশন গুলো করি yes item 8
my lord, I am for the applicant, my lord. In this matter, my lord, Mr. Rajesh Singh is appearing on behalf of the 8. My lord, I am for the applicant. I am the award holder.
okay
In 1993, my lord, I got the award. Challenging that award, the National Insurance Company filed an appeal, and that appeal was dismissed. Thereafter, I went to the department for withdraw the amount, but they're asking to approach before the court for appropriate order. Appropriate order has been passed. Thereafter,
no appeal is not yet disposed.
appeal is dismissed.
Appeal is dismissed.
Yes,
Let me
ma'am.
see the record.
Sir, आपकी petition ना. So
When was the order of dismissal passed?
yes, madam, that is dismissed for default.
Yes.
That is madam, in my application.
Anyway, thereafter it is restored.
No.
Not yet restored. When it is dismissed, let me see that.
Dismissed madam, 29/8/2019.
29/8/2019. Have a copy of that order?
Yes, madam. In my application, can 5, page 23, annexure A2.
You have a copy of that application, Can 5, Mr. Singh?
My lord, yes, I have.
Page কত বললেন দাদা?
Page 23. Can 5, page 23.
Yes. Yes, it was dismissed. Thereafter, no restoration application is filed.
No. I am the award holder.
So consequential orders, the amount can be withdrawn.
Milord, in this case, Milord, subsequently, I was briefed in this case, Milord. Prior to me, there were two earlier advocates, Milord. Milord, I believe both of them, Milord, retired or died, Milord. They are not available. So, Milord, in May 25, Milord, I was briefed in the case. Milord, the matter was last taken up, Milord. If your Lordship will kindly have a look, Milord, by Honorable Justice Ananya Bandopadhyay, when her ladyship
Unless
was.
the matter is restored,
Milord,
there is no
Milord,
need to take it up.
Milord, I understand, Milord, because matter, Milord, what my entry says, Milord, when I appeared last in the matter, Milord, in May 25, the matter was fixed in August 25. If Milord, I do not have the original file of my Lord. Last order, if my Lord kindly sees, then Milord, that was perhaps an erroneous order.
Anyway, you see,
Milord, I'll
order
file your
can be
Lordship.
passed unless the matter is restored.
My Lord is correct, Milord. My Lord friend is also correct.
So what is Can 5? Your Can 5?
Can 5 is, my lord. I went to the department. Department asked me that the
Oh, that's the
attainment of
majority. The regarding attainment of
yes,
majority.
attainment of majority. Yes.
But the question, yes, that is there. But
And prior to that, my lord, another order was passed regarding appropriate order. My lord, that is page 27 in my Can 5 application. From the record, it appears that the present appeal was dismissed for default on 29/8/2019, and till date there is no prayer for restoration. Learned counsel for the respondents present. Accordingly, in view of the order dated 29/8/2019, the matter has already been disposed of. Respondents are liberty to proceed in accordance with law. That is why I went to the department. My department said, you approach before the court for attainment of majority. So
let him take some instructions.
Milord,
If
I'll
there
take
is-
instruction,
if
Milord.
you
Your Lordship
don't
will.
file the restoration
My Lord,
application.
my Lord,
Yes,
my
to
Lord.
be allowed.
Yes, Milord, your Lordship will
the
kindly keep it after a fortnight, Milord. I'll come back, Milord. And if there is no merit in the case, Milord, I'll make it, Milord, clear before your Lordship to dispose it of there itself. But Milord, let me file the restoration, Milord.
Yes,
restoration,
record an order.
it will continue.
Learned advocates for the parties are present, as this matter is already disposed by passing an order of dismissal for default. No orders can be passed with regard to this application. Top. An application under Can 5 of application for recording the majority of appellant number 2 and 3.
2 to 5.
2 to 5 is taken up for consideration. Mr. Singh, learned advocate appearing for the appellant, prays for time to take necessary instructions and to take necessary steps. Thus, the matter stands adjourned till 29/1/2026.
Lordship.
Let it appear on 29/1/2026 under the same heading.
Grateful to your Lordship. Grateful. I'm obliged to my Lord.
Although this appeal has come at my instance. Earlier occasion, my lord, paper book have been filed and fixed for hearing as for orders. Now, my lord, this is a case where the claimants, my lord, preferred this appeal only two grounds. That the gross and net, my lord, net amount has been assessed, but it should be, my lord,
My lord,
gross
main-
amount, main paper book has been received.
My lord, date
I'm
will be
fixing for early hearing. Okay.
Yes.
This is the 2009 matter.
Short
Yes, I'm fixing for early hearing.
yes.
Yes, record an order. Learned advocates for the parties are present. As this learned advocates for the parties are present, as the matter is ready for hearing and the paper books filed, let this matter be listed for hearing. Stop. Considering that the appeal is of 2009, let it appear for hearing within first 10 matters on 20th January 2026.
তুই এদিকে আয়।
Milord, I am for the petitioner, Milord.
ট্রেনটা তুমি দুটো ইন্স্যুরেন্স কোম্পানি আছে বাজাজ আর My lord, this appeal has come at my instant. My lord, your lordship kindly see the order dated, my lord, on 22nd 4/2025, where her lordship, the Honorable Justice Anuna Bandyopadhyay, that this appeal be heard out, along with the another appeal preferred by the my lord insurance company.
So that is not appearing.
That is not appearing. My lord, your lordship kindly see the order dated 22nd 4/2024 25. এটা অর্ডারটা দিন না, অর্ডার শিটটা
আছে কি কোনো লেখা আছে?
আছে
ও, হ্যাঁ
অনন্যা বন্দ্যোপাধ্যায় 22/4/2025
আপনি ফাইল করে একবার দেখো ফাইলটা।
এফএমএটি 931
মনে কি করে রাখিস?
My lord, on that day,
একদম
an application for expeditious disposal was disposed of and allowed.
Okay, so a separate appeal is filed by the insurance company.
It gives the same award.
Now let this appear together.
My lord.
And my
Yes.
lord,
ফিক্স ফর হিয়ার
and fix for hearing, since my lord paper would have been filed.
Learned advocates for the parties are present. As this appeal is ready for hearing, let this appeal for hearing along with FMAT 931 of 2014
এটা নিয়ে আসতে হবে
এখানে নাম্বার পড়ে গেছে
on
FMA point.
20th. Same, I'm keeping it on 20th
ঠিক
of
আছে,
this
ঠিক
month.
আছে, হ্যাঁ
Not under the heading.
Yes,
কেন
Under the
20
heading for
78
hearing.
yes. Or 21.
My lord, whatever, my lord.
28
Okay, 21.
Because
One.
what I find, my lord,
28
this is increasing, that is already 160 matters.
But you see, the parties are not appearing also. There is no response.
না 28 বলছে
This is an old matter, 2016, 2009.
My lord.
Okay, 21,
21.
না, না,
1,
next week
21, my son was not there. My son was
Was
driving
not?
the car. I will not come, my lord. On
Okay.
Monday and
21 my son was
27, 27.
ঠিক আছে
27, 1, 2026. Within first 10 matters.
কোথায় গাড়ি চালাচ্ছে? ও গাড়ি না চালালে আমরা আসতে কি করে হবে? কেন আসবে না? ও ব্যাংকের
আমি তো টু বি মেনশনড ও মানে ফার্স্ট 10 ম্যাটার যদি বলে দিই 10:30 তাহলে ঠিক আছে। তাহলে এক কাজ করে দিন, ওটাকে ইয়ে করে দিন তো 10:30 ওই দুটো ম্যাটারই লিখে দিন। within first 10 matters না একটা হলো না না এই নট দিস উইক করে দিন তো, নট দিস উইক, নট দিস উইক। আচ্ছা ঠিক আছে।
But 12 Mother, I appear on behalf of the appellant. This matter of that second appeal, which was my lord's hearing, is to verge of completion. Today at 2 p.m. the matter was fixed. My learned friend for the respondent was going. They had to make submission.
No, you wanted some time to collect some documents.
No, that I mentioned this
No,
matter.
this is that cooperative matter.
Yes.
Cooperative second appeal.
Yes.
So you sought some time
No, I prayed before your lordship that the evidence
for
is correct.
supplementary paper book.
Yes, just may I make my submission? The record is there in your lordships. Last occasion while I mentioned before your lordship, my lord directed me to produce that record before your lordship. So the supplementary paper book will not, because those documents are not with me. It's a verge of completion because they are making their submission. My submission was completed. The records are there. We have agitated that paper in the law court record also. So it can be
So the
disposed.
trial court records.
Yes, here before your lordship only.
Yes, record and order.
Because it was fixed at today 2 p.m.
Yes. Learned advocates for the parties are present. Let this matter appear for hearing. এই যে দেখুন তো মানে 19 তারিখে 3টের সময় 2টো কি 3টের সময় আছে কিনা খালি। উনিশ তারিখে আচ্ছা 20-21 তারিখে দেখুন। হ্যাঁ আচ্ছা আচ্ছা 21 তারিখে appear on 21/1/2020। আচ্ছা তারপরে চলে যান তো এই 27 তারিখে তো নেই কিছু। হ্যাঁ না 2 p.m. 27/1/2026 at 2 p.m.
By the way.
So conclude it on
Yes,
the.
my exam, they are just verge of completion only. I will take only 5 minutes to give a reply, short reply. 22nd.
27.
As your lordship.
But I appear for the respondent. My instance of the matter has been no paperwork has been filed by learned friend lord till yet lord in spite of the directions.
My lord, I have obtained, my lord, all certificate copies from the TCR, my lord, for the purpose of preparation.
File the paper books within
Yes.
2 weeks.
2 weeks, my lord.
Yes, record and order. Learned advocates for the parties are present. As the paper books have not yet been filed, the time to file the paper books stands extended till second 2/2/2026. Let this matter appear on 3/2/2026.
Well, 16, I am for the petitioner. Well, my learned friend is appearing for the de facto. Well, this is a complaint case. This is an application for extension of interim order.
When will the order expire?
No, during the pendency of the application, when the interim order was subsisting, at that point of time, I have filed the application.
My lord, one vacating was also filed by me
Interim
earlier.
order is continuing.
No, my lord, interim order is not continuing, but prior to expiry, I have filed this application.
Okay.
Now, my lord, I beg to submit one thing. My lord, I had filed one vacating application. My lord, this matter is continuing since 23. Now, this lady was almost tried to commit suicide due to the, my lord,
My lord, kindly
torture.
fix a date for hearing.
Just a moment. My lord, his point was that this is second complaint and he took the point, but in the petition of complaint, earlier one was dismissed and I am covered by Honorable Supreme Court judgment. I had properly disclosed also. That is my learned friend's submission that in the second complaint is a bar, but actually, my lord,
Let it be decided by the regular bench.
yes,
That is only
my-
I have. Well, kindly fix a date.
But my lord,
Record and order.
my lord, my vacating application may be treated as my opposition and let them file reply and a date may be fixed. That is what I
Learned
beg to
advocates
appeal.
for the parties are
My lord,
present.
humbly submit.
It is submitted by the learned advocate for the opposite party de facto complainant that an application for vacating the interim order is filed. Thus, by consent of the parties, the application for vacating is treated as affidavit in opposition.
Great to know.
Pivot is granted to the petitioner to file reply on or before 27/1/2026.
But can it be on or before 30th minute?
27/1,
Malat.
27/1/2026.
I'm grateful, ma'am.
The matter may be placed before the regular bench on 29/1/2026. The interim order granted earlier stands extended for a period of 4 weeks till further orders, whichever is earlier.
Grateful.
Yes.
নাম দিয়ে দাও নাম দিয়ে দাও
One for judgment, four.
Item 4.
Four, I'm appearing on behalf of the appellant insurance company.
Claimant respondent. On the last occasion, the matter was adjourned on the prayer of the learned advocate for the owner. Well, today morning I have got a call from my pilot that he is because of high temperature he is not, and he has requested me.
Anyway, let it appear on Monday in the same position.
No, my lord,
I'm
he
making
has-
it not this week.
But he has said, my lord, it may be fixed on next Thursday, that is on 22nd.
কি রাজেশ দা বলছে নিপা হয়ে গেছে
Yes, record an order. Learned advocates for the
No.
parties are present.
সিটে পাঠাতে বলেছি বলে নিপা হয়ে গেছে
On the prayer of learned advocates, the matter stands adjourned till, yes, next Thursday is 22nd,
Right.
22/1/2026 at 10:30 a.m.
গ্রেটফুল ম্যাডাম
I'm appearing for the petitioner, Milord. Milord, I have served upon the
Item 17, my lord, I beg to appear on behalf of the private complainant, the opposite party number 2, my lord.
interim order is still, Milord,
Is
38.
there any application for vacating?
Milord, there
Yes,
is,
my lord. In fact, my lord, very similar to the last order passed, my lord.
Milord, there
The
is,
order was passed that the vacating is to be treated as affidavit in opposition. They had to file an opposition to that. Opportunity was given. Kindly read the last order, my lord.
kindly see the last order, Milord. The last order is that the liberty is given to the opposite party to file affidavit in opposition.
Let me see.
But I have filed it with the CRAN application. Milord, kindly see the CRAN application. It is an annexer, Milord.
So this is CRN 5.
But the item was to come up for hearing yesterday. It was fixed for 14th of January. It did not come up.
No, which order are you relying upon?
Page number 18, Milord. Kindly see my application, page number 18,
Page
page
18.
number 17, the last interim order.
Yes.
This is the last extension, Milord.
No, vacating
But-
application is filed.
Vacating application.
Yes, it was pending, long pending.
Now
The
the
liberty was to be
But-
treated as affidavit in opposition.
To file
They were
affidavit.
given the liberty to file a reply, which they have not.
did you file this affidavit in opposition?
Milord, I am the petitioner. They will file the affidavit.
No, the
No,
vacating.
my vacating is to be treated as an opposition.
That is not the order, Milord. Kindly say 18.
You see, the order is paragraph 8.
Yes.
On vacating application, CRAN 2 of has been filed by the opposite parties. Let affidavit in opposition be filed to the revisional application. Okay.
Yes.
So the affidavit in opposition, you are the opposite party.
I am the petitioner. They will
He is the
file.
petitioner.
File opposition to the main revisional application. Has that been filed? So file it within 1 week and thereafter serve a copy. Yes, record an order. Learned advocates for the parties are present. In terms of order dated 8/12/2025, liberty was granted to the opposite parties to file affidavit in opposition to the revisional application within 1 week. Stop. As the said affidavit in opposition is not yet filed, liberty is granted to the opposite parties to file the same on or before 29, 20. How much time do you require to file the opposition?
2 weeks,
My lord, may I say something? My lord, in item number 16, my lord had passed an order that the vacating application is to be treated as the my lord of affidavit in opposition.
That case, there was no earlier order. In this case, there is an earlier order.
Yes, my lord will kindly treat my vacating application as the affidavit in opposition.
Very well. If you want that, you do it.
My lord, my lord.
I'm granting you opportunity. If you want, you state that on the next day. Let the affidavit in opposition filed on or before. No, you want your vacating application to be treated as
Yes, to be treated as yes, my lord. Yes, my lord.
learned advocate for the opposite party number 2.
2.
That the vacating application filed be treated as affidavit in opposition. Thus, the vacating application is treated as affidavit in opposition to the revisional application. Liberty is granted to the petitioner to file affidavit in reply on or before 27/1/2000.
Give me 2 weeks time, my lord.
Okay, 29/1/2026. The matter may be placed before the regular bench on 3/2/2026. The date when it is going to expire?
30th January.
30th.
Granted earlier stands extended for a period of 4 weeks or till further orders, whichever is earlier.
Grateful.
3rd February, my lord.
And 5.
No, 3rd February, my lord.
Yes.
3rd February, my lord. Grateful, my lord. Most grateful.
আচ্ছা নেক্সট ডেটটা কবে রাখা হয়েছিল 3/2/2026 তো ওকে 3/2/2026
my lord, grateful.
You're the regular bench.
My lord, I am for the petitioner. Lordship, application, affidavit of service.
No, what is the urgency in this matter?
Urgency, what happened, my lord? Coming Saturday is the date fixed for framing of charge. But I have come before a lord.
No, is there any interim order, existing interim order?
No, my lord. But
So let the matter be heard before the regular bench.
my lord, what happened, my lord? Coming Saturday, day after tomorrow, the framing of charge will be held. So, my lord,
this is a matter of 2023.
My lord,
you did not obtain any interim order in the meantime.
My lord, kindly see, I have filed an application CRAN 1 for early hearing, my lord. There is. My lord,
Okay,
kindly.
the matter may be placed before the regular bench on, yes, record an order.
My lord, kindly. Then, my lord.
No, you want an early hearing.
My lord, short stay, kindly. Only for 7 days stay.
Had there been no order, had there been some order, I could have extended it. But you see, from 2023, you could not obtain an order. So how can I extend or pass an order?
So why, my lord, I have filed an application.
Okay, just record an order. Learned advocates for the parties are present. Learned advocate prays for an interim order on the grounds of urgency. On the grounds of urgency that the matter before the trial court is due to appear on when?
My lord, Saturday, my lord, coming Saturday, 17.
17/1/2026. Stop. Let this matter be placed before the matter may be placed before the regular bench on 20th January 2026. Stop. As the matter is sub judice before this court, parties may seek adjournment before the learned trial court, which may be considered.
Great.
Okay, copy is not yet served.
My lord, petitioner has already been served through mail.
Okay, copy of the application, if not be served upon the parties. If not served, be served upon the parties.
My lord, I appear on behalf of the respondent. Lord, I am for the appellant. Lord, only one difficulty may I point out before your lordship. Lord, my lord, kindly see my lord's last order.
Which application? What application is pending?
No, my lord, the application have been disposed
Matter
of.
is admitted by the division bench.
Division bench earlier, thereafter your lordship, my lord, allowed my lord the application for injunction till disposal of the appeal. Today, virtually, my lord's endeavor was that with regard to the other my lord preparation of paper book and the other procedure for hearing of the appeal,
whether can be, my lord, made ready or not to ascertain that your lordship kept, my lord, the matter today. My lord, kindly see my lord's last order dated 9th of December 2025. Has your lordship got
Paper
it, my
books
lord?
we filed on or before January 13.
That is, my lord, to my learned friend has filed. Now, my lord, your lordship directed the appellant shall take steps to cause service of notice upon the respondent number 226 as already directed by the order dated 3rd March 2025. This 3rd March 2025 is the division bench admission order. If your lordship go back to that order, my lord would see the division bench never directed us, my lord, rather the appellant, to cause service of notice of appeal to the, my lord, through department.
My lord,
They are
in
lodged.
my
Dara
humble
Baba, ekটু
submission,
dara.
that is not even required because in the appellate court, before the first appellate court, we were the only appellants. We are the one who is
So
contesting.
you are the plaintiff respondent.
He is the plaintiff.
He is the plaintiff.
We won before the trial court. Before the first appellate court, it was my appeal. And I won in that appeal.
The other respondents are the parties to the suit.
They are parties to the suit, but the appeal was carried forward by me only.
So, my lord, without
What
any
was the
application,
status in the suit? Plaintiff or defendant?
Defendant. I was the defendant.
So
Their suit was specific.
decree was passed against you,
Yes.
not against the other parties.
my lord, today, without any application for dispensation, my lord, I do not think, my lord, this can be done subject to my lord's, my lord, pleasure. Now, my lord, what I am pointing out before your lordship, the division bench by the order dated, my lord, which your lordship directed to carry out 3rd March 2025.
That is the usual process. Serve to the department. If you are unable to serve them,
That was not the direction. Until and unless your lordship direct me to file the requisite, the department will not accept. Your lordship kindly direct that. I want that.
Yes.
My lord, if I may.
And I do not know whether the TCR has come or not.
Lordship may kindly keep it. Today is a Thursday. My lord may kindly keep it on Monday because if I am able to recollect, I do not know. I think requisites have already gone in. I do not know. I will check with my clerk and the advocate on record. If not, Lordship may kindly pass a direction on me. My Lordship can do that. Lordship may kindly pass a direction.
yes,
on
record
me.
an order. Learned advocates for the parties are present. It appears from record that steps were not taken to cause service of notice upon respondent number 226. You are respondent number 1.
I am respondent number 1.
Thus, liberty is given to both appellant and respondent number 1 to file requisites for causing service upon respondent number 226.
And will special messenger cost also for bringing the trial court
The
record.
trial court's records we call for at the special messenger cost of the appellant.
Of the respondent, I will put in everything.
At the special messenger
LCF
cost.
is already there, Lordship. That is the confusion. Lordship, may I please clarify? Lordship may kindly take the record because the
that is
LCF
there.
has already come in.
আচ্ছা ওটা কেটে দিন trial court records ওটা কেটে দিন.
I shall only serve requisites for notice.
Yes. Let this matter appear on 3/2/2026, 3rd of February.
My
May 4th of February.
no, my lord, 4th, 5th, and 6th, I have certain problem. 3rd, I don't have any problem.
Lordship, may it be 2nd of
Okay,
February.
2nd February 2026.
Grateful.
And Lordship may kindly record that the paper books are ready. It has been filed in the department and a copy has already been served upon the appellants.
Okay, the paper books which are already filed in the department, we put up on the next date fixed, and copy may be collected by learned and
I have already served.
the paper books which have already been filed in the department, we put up on the next date fixed.
And I have already served upon.
Okay.
They have received.
Two appeals.
So from the one order, 2 appeals have been preferred.
Since there was a cross appeal, that's why before the appellate court, that's why 2 second appeal.
Okay, it will be hard analogously. Same order.
Yes.
Same order for both the appeals.
Yes. That will suffice. Great formula.
Thanks.
Twenty-one and 22, my lord, I am for the cross objector.
Lordship, I'm there for the appellant. I'm seeking a short passover in this matter.
Okay, not today.
Then, my lord, kindly take it tomorrow. Tomorrow there will be oath of Honorable Chief Justice.
Okay, not this week.
Monday, my lord, Monday.
Not this week means Monday.
Monday. Monday, my lord. Deeply.
23, my lord. I'm for the appellant, my lord. But I have not filed any stay application since, my lord, the award has already been executed as my instruction. My lord, kindly grant me 3 weeks time. I shall take instruction from my client whether my client is really willing to proceed with the appeal or not.
Yes, record an order. Learned advocates for the appellant prays for time to take necessary instructions in the facts and circumstances. The matter stands adjourned till 3/2/2026.
Well, 24, kindly make this not this week. Kindly not.
Okay, not this week.
Deeply, please.
Respondent.
24, but in this matter, I am appearing for the.
No, prayer is made for not this week.
Not this
Monday.
Monday.
For correction. There is a typographical mistake.
It is disposed matter.
Disposed matter. Kindly see 2nd December 2025 order dated. ওইখানে লেখা আছে হ্যাঁ হ্যাঁ
That is page, which paragraph?
That is, my lord, kindly see, my lord, 2nd December 2025 order.
Yes. Which paragraph? There is
My lord,
mistake.
not paragraph, my lord, kindly see the case number. FMA 452 of 2025. It
Oh,
will
right.
be-
It is the
Yes.
cost title.
Yes.
Yes, record an order. Learned advocates for the parties are present. The matter is put up for necessary rectification in the case number of order dated 2/12/2025. In the case number, it is recorded as FMA 452 of 20258 instead of 2025. Let necessary rectification be made. Other contents of the order dated 2/12/2025 remain unaltered.
Pledged.
Lord, I am for the appellant.
On the last occasion, my lord, when this matter was taken up, my lord was pleased to grant me leave to give my affidavit in opposition to Can 1. My lord, the difficulty I am having, I tried to draft the opposition, but the discrepancy, my lord, will kindly come to Can 1 once. I could not. The facts are so jumbled up.
Not make it ready.
No, it's a bit difficult for me to prepare the opposition. My lord will kindly see the facts are absolutely jumbled up. I'll just show, my lord, that why I could not prepare the affidavit in opposition. Can 1.
You obtain instructions, whatever
My lord will just see once. Once my lord will kindly see. Now Can 1, it's for application for appropriate order. Right? Right? Can 1 ta. It's application for appropriate order, my lord, for
Minor to major.
attainment of majority of this 4 appellants.
Yes.
Now this at page 9, page 8, my lord will kindly come. This is appellant number
3.
Abu Sattar Mukami.
Appellant number 3.
Yes.
All these appellants, my lord, they are these other cards, my lord. It says that they are the children of one Hasan Ali Mukami. All other cards, it says that they are the children of Hasan Ali Mukami. And my lord will now kindly come to page 10 once. Annexure E. It says Abul Hasan Mukami. This
Okay, whatever you want to take, whatever stand you want to take, you incorporate it in your.
now, my lord will kindly come to can 2. Can 2, my lord will see. One of them, appellant number 4, minor Hasanur Mukami. My lord will kindly come to can 2.
Yes.
Hasanur Mukami, now page number koto. Annexure, the last but one annexure, and annexure H, my lord. He is the son of Abul Hasan Mukami. Now this basic, the confusion is regarding.
Whatever you want to state, you state. It is for your learned friend to clarify in his reply. Yes, record an order.
My lord, I am ready to reply.
Let her file the affidavit in
My
opposition.
lord, already 15 days have passed.
I then my lord, one thing will kindly, my lord will kindly
See,
then
whatever you
one
want to.
1 minute. My lord will
Yes.
kindly then grant me leave to file opposition.
Several years.
Opposition to both can 1 and can 2
Yes.
because my lord had
Both are to
only.
be- Both are to be.
Yes.
My lord, another thing, I have due to mistake, I have filed the birth certificate of the deceased. Actually, it will be death certificate. Now I am filing the death certificate, my lord, kindly.
File it by way of supplementary affidavit, sub copy.
Achha, all right.
Okay. Learned advocates for the parties are present. The time to file affidavit in opposition to can 1 of 2025 and can 2 of 2025 stands extended till 22/1/2026. The reply, if any, may be filed by 29/1/2026. Let this matter appear on 2/2/2026.
My lord, early, actually.
Anyway, file your reply. Thereafter, within 2 days, it will appear.
কি বলছেন এটা আপনাকে করতে বললো
করে দিচ্ছি
সেটাই বল একবার জেনে
My lord, the annexure, the death certificate will be supplementary affidavit, my lord,
Yes.
direction.
A liberty is also granted to file supplementary affidavit.
21 আর 27 দিল 21
22 আর
29
reply 22 আর 2টা আবার থাকবে 28 my lord, I am appearing on behalf of the appellant insurance company. I have served. This is my affidavit of service.
Regarding what? Section 5?
Section 5. I have served all the connected applications as well as the memorandum of appeal. I am giving the challan. I have also deposited 25,000. I am praying for interim stay. Right. আমি appellant.
This can 2 is for the section 5.
My lord. Can 2 is for stay. Can 1 is of section is for section 5.
Section 5.
It's a change brief, so the
Yes, record an order. Learned advocate for the appellant insurance company is present. None appears for the respondents in spite of service of notice. Let the affidavit of service filed be kept with the record. The application for condonation of delay is taken up for consideration. Upon perusing the grounds furnished and upon hearing the learned advocate, this court is of the view that the petitioners have furnished grounds for condonation of delay. Thus, delay in filing this appeal is condoned. Can 1 of 2024 is disposed. The Can 2 of 2025 is taken up for consideration. The appellant insurance company has deposited the statutory amount of rupees 25,000. Stop. As the statutory amount of rupees 25,000 is deposited by the appellant insurance company, there shall be an ad interim order of stay of the judgment and award dated 4th July 2023, passed by learned Additional District Judge Haldia, Purbo Medinipur, in MSC case number 7 of 2016 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court, excluding the statutory amount deposited within period of 5 weeks. Stop. In the event the awarded sum is deposited within period of 5 weeks, the ad interim order of stay shall continue till disposal of this application. Stop. The Registrar General High Court Calcutta is requested to deposit the to invest the awarded sum in a fixed deposit of a nationalized bank and renew the same from time to time. Liberty to mention.
My lord, grateful, my lord, deeply obliged.
There are two applications, one for continuation of delay and another for stay, my lord. I have served, my lord. I have sent one a copy of application, my lord, and they have received. The track report shows that the item delivered. হ্যাঁ 565 I have also deposited the amount of statutory. Track report shows that the item delivered upon the respondents. But as per my calculation, there's a delay about 21 days in filing the application.
Yes, record an order. Learned advocate for the appellant insurance company is present. None appears for the respondents in spite of service of notice. Top. The affidavit of service file be kept with the record. The application for condonation of delay being Can 1 of 2026 is taken up for consideration. Heard learned advocates for the appellant. Peruse the petition filed. Upon perusing the petition and upon hearing the learned advocate, this court is of the view that sufficient ground is furnished for condonation of delay. Thus, delay in preferring this appeal is condoned, and the appeal is admitted. Can 1 of 2026 stands disposed. Top. Yes, where is the other application?
That is Can 2 is stay application.
Can 2 ta din? Huh? The application for stay being Can 2 of 2026 is taken up for consideration. As the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated 11th April 2025, passed by the learned Additional District Judge, 3rd Fast Track Court, Berhampur, in MSC case number 575 of 2015 for a period of 5 weeks. Stop. The appellant insurance company shall take steps to deposit the entire awarded sum within this period of 5 weeks. Entire awarded sum along with interest as directed by the learned trial court, excluding the statutory amount within this period of 5 weeks. Stop. In the event such deposit is made within this period of 5 weeks, the ad interim order of stay shall continue till disposal of this application. The Registrar General is requested to invest the sum deposited in a fixed deposit of a nationalized bank and renew the same from time to time. Liberty to mention.
Grateful.
For 31, I am appealing on behalf of the respondent claimants, my lord.
Delay is 58 days.
Delay is how many days?
58 days. Yes, communicated. Yes, applicability loss.
My lord, in the application, it has been stated 87 days. My lord, I am leaving it before your lordship.
Yes, 58 days.
Learned advocates for the appellant insurance company and learned advocate for respondent number 1 claimant are present.
Respondent number 1 and 2.
Respondent number 1 and 2 claimants are present. The application for condonation of delay is taken up for consideration. Hard learned advocates peruse the petition filed. Upon hearing the learned advocates and upon perusing the petition, this court is of the view. Section 5 টা কোথায়? এটা কিন্তু can 2 টা কোথায়?
Can 2.
This court is of the view that sufficient ground is shown for condonation of delay. Thus, delay in preferring this appeal is condoned and the appeal is admitted. Stop. Can 2 of 2025 stands disposed. Yes, regarding Can 1, have you deposited the statutory amount?
Yes, 25,000 deposited.
Yes.
With affidavit of opposition.
In this case, my lord, liberty may be given to the claimants to file, my lord, paper book, my lord.
Learned, the application for stay being Can 2 of 2025 is taken up for consideration as the appellant, hard learned advocates, as the appellant insurance company has deposited the statutory amount of rupees 25,000, there shall be an ad interim order of stay of the judgment and award dated
memo copy দিয়ে দেবেন স্যার, হ্যাঁ?
14th day of May 2025 in 14th May 2025 passed by learned additional district judge Gangarampur at Bunyadpur in MSCC 1 of 2025 for a period of 5 weeks. The appellant insurance company shall take steps to deposit the entire awarded sum along with interest as directed by the learned trial court, excluding the statutory amount within the period of 5 weeks. Stop. In the event such deposit is made within the period of 5 weeks, the ad interim order of stay shall continue till disposal of this application. The Registrar General High Court Calcutta is requested to invest the deposited amount in a fixed deposit of a nationalized bank and renew the same from time to time. Stop. The learned advocate appearing for respondent number 1 and 2 prays for time to prepare the paper books. Such leave is granted. The paper books be filed on or before 2/2/2026 and copy be served. Let this matter. Achha, trial court's records have come.
No, no, no. My lord, kindly, my lord, pass an order to
The trial court's records be called for at the special messenger cost of the appellant.
my lord.
Respondent number 1 and 2.
No, no, no.
Let this matter appear on 5/2/2026.
My lord, I am for the appellant insurance company. My lord, in this matter, we have already deposited statutory amount 25,000.
Item 32 here for the appellant.
I am for the appellant insurance company. My lord, we have a
There is no delay.
delay, my lord.
There is delay.
42
Have you
days.
served this
No, my lord, not yet.
section 5?
So, as your lord, this is only 42 days delay, my lord.
Whatever it is, section 5 cannot be taken up unless you serve.
Or lordship.
So nobody has, because unless you serve, nobody can enter appearance.
Lordship.
Okay, I'm keeping it next week. In the meantime, you serve.
Lordship.
Learned advocates for the, you keep that with you. Okay, on the next day you file it.
Lordship.
Learned advocate for the appellant insurance company is present. The application for condonation of delay is taken up for consideration. As this application for delay is required to be served upon the respondents, let the service be effected on or before 20th, on or before 22/1/2026.
22, my lord, let it keep after 22nd, my lord.
Okay. On or before 27/1/2026. Let this matter appear on
My lord, my lord, the leave may be granted to correct the name of the learned tribunal judge, my lord. That is
let this matter appear on 28/1/2026. Liberty is granted to
not my 28. Lordship may take it after 28, my lord.
No, you serve it in the meantime.
Yes, my
Is there any execution proceedings pending before the trial court?
No, not yet.
Okay. So cause service on or before 27/1/2026. So let this matter appear on 3/2/2026. Liberty is granted to cause necessary correction in the cause title of the memorandum of appeal.
My lord, learned tribunals judge.
With regard to the name of the learned
tribunal
trial court judge.
Lordship, I'm grateful.
Item number 30, pardon me. Item number 30, I am for the claimant is coming.
Wait. Yes.
I appear on behalf of the appellant insurance company.
I appear for the respondent.
Yes.
Yes,
Is there
can
any-
application, there is a delay application and stay application.
And one is delay.
Yes. আছে delay আছে 441.
Yes, record an order. Learned advocates for the appellant insurance company and learned advocate for respondent number 1.
Respondent number 1.
One claimant are present. The application for condonation of delay is taken up for consideration. Heard learned advocates peruse the petition filed. Stop. Upon perusing the petition and upon hearing the learned advocates, this court is of the view that sufficient ground is shown for condonation of delay. Stop. Thus, delay in preferring this appeal is condoned. Stop. The appeal is admitted and the application can 1/2026 stands disposed. The application for stay being can 2 Yes.
I have
Where is
deposited.
that can two? Can two to the the application can two of 2026 is
My lord.
taken up for consideration. The appellant insurance company has deposited the statutory amount of rupees 25,000. Stop. As the statutory amount of rupees 25,000 is deposited, there shall be an interim order of stay of the judgment and award dated 29/6/2024, passed by learned additional district judge, first track third court Howrah, in MSC case number 204 of 2013 for a period of 5 weeks. Stop. The appellant insurance company shall deposit the entire awarded sum along with interest as directed by the learned trial court, excluding the statutory amount within the period of 5 weeks. Stop. In the event such deposit is made within the period of 5 weeks, the ad interim order of stay shall continue till disposal of this application. The Registrar
my lord.
General High Court Calcutta is requested to invest the deposited amount in a fixed deposit of a nationalized bank and renew the same from time to time. Yes.
My lord, since I enter appearance on behalf of the respondent number one, and respondent number two is the owner, my lord, he did not contest. So, my lord, on behalf of my lord, because I have filed a cross objection, that is COT 184 of 2000.
So in that have you served?
Yes, that.
Yes, yes.
Service is complete
yes.
upon all the vehicle owner also.
My lord, vehicle owner's agency is not required.
No,
We-
suppose if there is a case of the breach
No,
of
no,
policy.
and the commander. Only point involved whether the minor, the age recorded in the postmortem report or the age recorded in Aadhaar card would be relevant. This is the only point. Here the quantum point is.
This is the point by the appellant insurance company.
Appellant insurance
And from your side, there is a quantum
My
of
lord,
award.
my point is that my lord, the parental sister is the claimant, my lord. So she is entitled to get, my lord, the consortium, parental or filial consortium. That is the only point. Other point is also my lord, the grounds taken by the insurance company has no merits because there is a judgment of our High Court that the age recorded is PM report is much more, my lord, acceptable. Rather, age recorded in the Aadhaar card. There is a judgment.
You have to file the paper books.
Let them file the
The trial court records we call for at the special messenger cost of the respondent number.
No, my lord, he is to report. He is appeal. Because I did not, my client did not get a.
Let the workout record be called for, my lord. No special message
The
required.
trial court records we call for. The paper books be filed by the respondent number 1 on or before 2/2/2026. 2nd of February.
And matter be fixed on.
Thereafter,
I fix the date.
2/2/2026. Let this matter appear on 5/2/2026 under the same heading.
Give the approach.
I will kindly record my court COT 184.
Okay, let this appeal appear along with COT
184 of 2025. Be tagged.
184 of 2025. Is there any delay in filing that? No, there has to be a delay. If there is a delay in the main appeal, there will be a delay in your side.
My lord, appeal file, my lord, in the month of in the month of September, and my lord, in the month of December, and I also filed court in the month of December. 30 days time is, my lord.
For the opposite party, my lord.
Huh?
Seven.
Seven. I'm for the petitioner. On last occasion, my lord.
My lord, I think this matter will taken time. Mental academy means for 1 hour, so that
Okay, the other matters are really still recess.
much of much. Great.
Huh? Supplementary are written notes of argument. Are written notes of argument. এই এভিডেভিট সাবজেক্ট এটা আজকে একটা এভিডেভিট দিচ্ছি সাপ্লিমেন্টারি এভিডেভিট আর হচ্ছে রিটেন নোটস অফ আর্গুমেন্ট
So in this matter, Mr. Poddar is appearing
Yes,
for the other side.
Yes, sir.
So after you conclude, he has to submit.
No, I partly conclude, but
No, after your submission, he has to submit.
this is the supplementary affidavit. What I have stated, because on last occasion,
The written notes.
সাপ্লিমেন্টারি আগে দিন না না এটা না সাপ্লিমেন্টারি আছে সাক্ষী দিয়ে বলছে সত্যেন্দ্র মানে the relationship among the opposite parties with the petitioner.
You have served copy of the supplementary
yes,
affidavit.
All served. My lord, the question is that whether I have made out a prima facie case both in regard to the situation as deserving and also prima facie rights.
The question is where this matters before the trial court. That is the question. Not that you can place it now. If this were not before the trial court.
I have placed by way of application for amendment.
No. When the application for injunction was moved, where this matters before the trial court. That is the thing.
No, I only the question.
Unless it is there, you see, the court cannot take cognizance of all these things.
No, I am not on the point. I am on the point. There is a relationship because
See,
of
that has to be established in the suit, okay?
Yes.
While considering the injunction application,
In regard to the prima
on the
facie.
basis of the plaint and your injunction application,
Yes.
whether there was a prima facie case to grant you identity.
Now your lordship
That is the
only take 2 minutes, my lord. Only take 2 minutes. My lord, kindly see page 157. Page 157. The opposite parties adduce the evidence in their eviction suit. What I have stated that there is a relationship of the petitioner with the opposite parties. My lord, only the point.
157.
Page 157. Page 157. the opposite parties adduce the evidence.
See, while considering ad interim injunction, court has to confine
Prima facie.
within the plaint. Okay.
Plaint
Plaint and the documents.
and the documents.
Yes.
And the
So
documents.
these questions were not there. Okay.
No,
Now you cannot improve your case.
I have no, I am not improved. I have placed these documents that was not considered by the learned trial court. That is the points. My lord, kindly see that on evidence what he have stated, my lord. Only just the points. Today I have not filed the will and probate of the will executed by Nilmoni De. Nilmoni De was the original owner and testator. I shall file the relevant documents on the next day. Nagendranath De had 4 sons, namely Khagendranath De, Robindranath De, Satyendranath De. They kindly pointed out Satyendranath De and Phonindranath De. Phonindranath De is my grandfather. Khitindranath De had been died without any issue. Robindranath De had 1 son and 5 daughters. Out of them, only Sheila Ghosh Majumdar is still alive. Sheila Ghosh Majumdar has only 1 son and he is still alive. Ira Dotto has 2 sons and they are still alive. Chayarani Ghosh has only 1 son and he is still alive. Mayarani Ghosh has 1 son and 1 daughter and both of them had been died. Indira De had been died being unmarried. Rothindranath De had been died along with his wife without any issue. Now come to the point, paragraph 17 and 18. That is the more vital. Satyendranath De, kindly noted it, Satyendranath De had 2 sons, namely Sujoy De and Sanjay De. Now I come of Sanjay De. Sanjay De. Sanjay De, being the legal heirs, I am stepping in the shoe of Sanjay De. And both of them had been died being unmarried. This is the false statement adduced before the learned trial judge in eviction suit, unmarried. Now, kindly quoted it, not a fact that Sujoy De had been died leaving behind 1 son and wife. That is the more vital. Now, whether the Sujoy De and Sanjay De had died bachelor, so Lordship will find on last day.
The plaintiff is the legal heir of
Satyendranath De.
Satyendranath De.
Satyendranath De.
Okay. So Satyendranath De. And regarding Satyendranath De, how many heirs are there? Yes, had 2 sons, Sujoy De and Sanjay De.
Now I am stepping in the shoe of Sanjay De.
No, the plaintiff is heir of whom?
Sanjay De.
Sanjay De.
Sanjay De. Now
is the plaintiff is accepting
yes,
this version.
Yes,
That Satyendranath De had 2 sons, Sujoy De and Sanjay De.
Now stepping in the shoe of, so there is a relationship. Now your lordship will find page 169. What that has also been on last occasion I have relied upon. Soumik De, page 169. I again reiterate. Page 169. This evidence.
Yes.
This affidavit has been filed before the Honorable Division Bench when my uncle was died. Soumik De, that is the petitioner herein. Now, para 1, I say that I filed the CAN application being CAN number such and such in FAT number. I say that one let Satyendranath De was my grandfather who died on such and such, leaving behind his widow, namely Subarno De, since deceased, and 2 sons, Sanjay De and Sujoy De. So there is a similarity. I say that my father, namely Sujoy De, died intestate on such and such, leaving behind my mother, Sutapa De, and myself. I say that subsequently my uncle Sanjay De, that is the more pertinent, being the sole appellant herein, died bachelor on such and such, leaving behind.
This is the affidavit of this
petitioner here
in this court of
appeal.
No, in this court of small causes.
Yes, evidence adduced by evidence.
Your case is before the court of civil judge, that where the
eviction proceedings initiated by.
This is not, you see, this present revisional application is against the suit for declaration and that injunction of that Sebaid chief rights.
Along with partition of rights of Sebaid.
Yes, that is there. And this is on behalf of the applicant in a suit for eviction in the small causes.
No, this applicant is the applicant in connection with a first appeal pending before the Honorable Division Bench connected in another suit. Who filed the suit? Filed the suit by the opposite parties against my uncle. Against my uncle filed a separate suit before the learned 10th Judge City Civil Court at Calcutta, and against the judgment and degree my uncle Sujoy De preferred and first appeal before the Honorable Division Bench. So I pointed out the connection in between the petitioner with the opposite parties. There is existence of right that has been
You are from Sujoy De.
Sujoy De.
That is the plaintiff.
That is the
Plaintiff petitioner is claiming the rights from Sujoy De.
No. I am.
There is another De, that is Somendro.
No. Kindly
Present petitioner, who is the plaintiff before the trial court.
Petitioner Soumik De is the plaintiff before the trial court and appellant before the appeal court in respect of partition suit.
That is the suit in question.
Suit
which
in
we are
question.
dealing.
Suit in question.
Yes.
Now the question is that whether I have any right or sujuri in respect of the property in question or not. That is why I pointed out the evidence adduced by the opposite parties in an eviction suit instituted against a person.
Third party.
Third party. Wherein it is admitted by him that yes, Satyendranath De, I am the Sujoy De and Sanjoy De, my father and my uncle were the legal heirs of Satyendranath De. Now I stepping in the shoe of my uncle Sujoy De. Sanjoy De. Now, para 4, kindly noted it. Para 4, my lord kindly noted it, very much pertinent. I say that subsequently my uncle named Sanjoy De, being the sole appellant hearing, appellant before the Honorable Division Bench, died bachelor, leaving behind me the applicant as sole illegal heir, nothing more than. So my right devolved after the demise of my uncle Sanjoy De. Kindly noted it, para 4.
Paternal uncle.
Paternal uncle. So this para is very much pertinent. Kindly noted it. According to this right, I came up for application for substitution in the appeal court when my uncle Sanjoy De died as bachelor. Now, Lords will find that page 174. Page 174. That is the order of the Honorable Division Bench. In view of the affidavit disclosing the family tree and justifying that the applicant is a legal heir and representative of late Sanjoy De, the appellant, the application for substitution being can number is allowed, applicant is otherwise major, sue juris, the right to sue survives. So this is the party. So my right devolved from my uncle. And the evidence which have been adduced by the opposite parties in the trial court in connection with eviction suit, that he also stated that there is a whisper of Sanjoy De and Sujoy De, whisper of my father and my uncle. So that is the chain in between the parties. Chain, only to say the chain of relationship. Now the question is that what offense committed of perjury? The order passed on, my lord, kindly see 174 page again. Order passed on before the division bench 13/12/2019. Kindly noted it. 13/12/2019, the order passed by the Honorable Division Bench admitting my right. And now the evidence adduced on Evidence adduced on, my lord, kindly see again I 157 on 25th November 2021. 157 again I. Evidence adduced on 25th November 2021. So after the order passed by the Honorable Division Bench admitting my right as a appellant before the Division Bench in the year 2019, the evidence adduced on 21, that is the case of perjury, false representation, because he stated on the paragraph 17 and 18, line 17 and 18, that Sujoy and Sanjoy died living bachelor. So it's a false statement. I filed the application under section 340 before the learned civil judge. It's a false statement, absolutely. It's a case of perjury. And the matter in connection with that pending before the Honorable High Court in criminal division matter. So this is the more chain. There is a chain of Satyendranath. He admitted there is a legal heirs of Satyendranath there. Who are the legal heirs? Sujoy De and Sanjoy De are the legal heirs of Satyendranath. He admitted. And he stated falsely after passing of the Honorable Division Bench order that there is no legal heirs. But legal heirs that has been admitted in the year 2019 before the Division Bench. So only to say the chain, there is a chain in between petitioner with the opposite parties. I have to satisfy because there is a evidence, there is a document. Kindly noted, this is the most pertinent to this matter for adjudication. Admitting Satyendranath De, Sujoy De and Sanjoy De, their existence, their right is there, and only to say that it's a false statement. That is why the case of perjury has been initiated. And now, I'm not on the facts again. Now, only to the question of law point in my written notes of argument. In my written notes of argument, only this citation, that is the Anand Prasad, page number 109. Reportable judgment, AIR 2001, Supreme Court, page 2367.
Yes.
Page 109, that is the reported judgment. My lord, next page, that is the more pertinent, page 111. Page 111. I put the question that whether the learned trial judge or the Court of Appeal has any scope to take any mini trial. Now, I pointed out that it may not be appropriate for any court to hold mini trial at the stage of grant of temporary injunction. So that is the crux of the matter. All the matters should be decided by taking evidence. And at this moment, when the ad interim order of injunction has been prayer for refused, so the learned trial court and the appeal court holds the mini trial, that there is no documents, etc., but not without going to the merits of the matter and the apprehension of imminent danger. That is the question. Apprehension of imminent danger at the instance of the opposite parties. So this judgment is most pertinent, that at the time of the ad interim reliefs, even that the temporary injunction application hearing, there is no scope for holding any mini trial. Now, I conclude. Now, my brother will give reply, and then I submit.
And we've been served with a copy of the supplementary affidavit.
Sir, but I think, my lord, that is not required to deal with.
No. Do you want to deal with this?
No.
Anyway.
That is not required. That is made just to make the file heavier. First of all, First of all, your lordships kindly appreciate against which order my learned friend has come up before this honorable court. He initially, before the trial court, approached with a prayer for temporary injunction under order 13.
ইয়েটাতে কি filed, main filed.
Order 39, Rule 1 and 2. In a suit, in a title suit being number 202 of 2024, page 28. Page 28. The copy of that plain annexed in the application under Article 227 from running page 28 to 53. My lord, kindly have a look. Page 28 to 53. This is about the copy of the plain. Copy of the plain. No copy of temporary injunction as prayed for, which was refused by the court below at the ad interim stage, was not annexed in the application. In main application under Article 227 of the Constitution of India. Rather, he preferred to annex the copy of the plaint. Number one. My lord, my first question to myself, that since the prayer for ad interim order of injunction was refused by the learned trial court below, holding that lacking prima facie case, my learned friend is very much vocal to the said word, having no, that sentence, that petitioner failed to make out any prima facie case. So, after having the application under Order 39, Rule 1 and 2 at the temporary stage, what the duty of the learned trial court? Either to grant relief in the form of ad interim order or to refuse it with reason. One of the reason is that petitioner failed to make out any prima facie case. Amongst the three reasons, balance of convenience, prima facie case, and irreparable
loss.
Yes, this is the golden principle everyone in this profession knows. So, my learned friend taken very much exception that why the court below refused his prayer, as if it is a bounden duty on the part of the learned trial court to pass ex parte ad interim injunction order in all prayer, in all matter. It is not. Where merit bears only.
Yes, if the three conditions are fulfilled.
Yes. Golden principle. And while refusing the same, the court directs to serve notice upon the defendant opposite party. Till today, no notice was served. Rather, he preferred one BSAP before the learned appellate court. Appellate court also held no document, nothing of sort in support of his contention made in either in Order 13, Rule 1 and 2 or application for injunction before the learned lower appellate court. As a matter of fact, the court gone against him.
That means ad interim order was diffused by the appellate court
also. So it becomes a concurrent finding.
Yes.
Now, my lord, kindly consider, for argument's sake, I am taking the argument advanced by my learned friends as all acceptable at this juncture. So, what the Honorable High Court can do under such circumstances when the plaintiff petitioner come up before under Article 227 of the Constitution of India on being aggrieved by the refusal of order of ad interim injunction by the both tier. What this court can do, it is not in appeal. So court can't usurp the jurisdiction of the trial court. Ultimately, injunction application is very much pending before the trial court. It is the duty of the trial court to hear it out on merits, hear it out on merit on contest. So, without going for that path, without giving opportunity to the learned trial court to hear out the injunction matter, trial court may find it that yes, there is a very much good case. Trial court may grant injunction after hearing both parties. Why my learned friend are so apprehensive that trial court must not give injunction in his favor at this juncture?
No, question is, what is the imminent exigency that in the meantime, some irreparable loss will take place?
Nothing happened, your lordship. Visualize this. When they approach before your lordship, 2024 puja vacation. Now it is we are 26. Now I am coming.
No, 24 they got a protection order.
Protection there.
But up to 24, whether anything happened?
Nothing happened. When the ad interim protection was not there even. Sometime in about 15-16 months, the matter is before the High Court.
You see, now the question is whether the trial court and the appellate court are in refusing the ad interim order. Okay. Because you see, even if an ad interim order is passed or some protection is given, you will not be prejudiced because ultimately on the basis of affidavits and the documents, the court has to decide.
Yes,
okay.
I am on there.
No, so neither, you see, even for argument's sake, this ad interim order is granted till disposal of that injunction, you will not be prejudiced. Factually, whether the trial court has erred or not, that's a different issue. But you will not be prejudiced by if some interim protection is given during this period.
My lord, kindly see. Before answering, I will not be prejudiced because I know it very well. What right he has. Because kindly come to page 54. Page 54. The thing has been decided by the learned City Civil Code in 982 of 1997. Thing has been decided. Res judicata section 11. There is a provision under section 11 of the Code of Civil Procedure, res judicata. The issue has been decided between the parties.
Anyway, you see, you will not be prejudiced.
I never be prejudiced. I only beseech your lordships that High Court under this juncture, my learned friend relied upon one of your lordships' judgment. I am wholeheartedly agreed by the judgment passed by your lordship that at this juncture, court say it is a duty of the learned trial court against whose file the main injunction application is pending for disposal. So, since High Court is not in appeal, so the learned trial court will be given opportunity to dispose that matter. So, High Court can't direct there will be an injunction or there will be not.
The question is, even if the High Court passes, either of the parties will not be prejudiced.
Not be prejudiced.
Because ultimately that injunction has to be decided.
The court will.
Okay, but in the meantime, a temporary protection order will not prejudice any of the parties.
Yes. Now your lordship.
Whether the court in exercise of 227 powers will pass or not, that's a different issue. In exercise of the power under 227. But it's an admitted position, your client will not be prejudiced for the short period.
For that reason, for that protection, the petitioner before your lordships must made out that case that they are going to sell or they are going to purchase or they are going to destroy, they are going to induct it.
No,
nothing of sort.
What is your stand? Whether you will be prejudiced for this 4 weeks or something limited?
thing is, I will not be
Because I have
prejudiced.
to see the,
I will not be prejudiced. Whether they will be prejudiced, what right they had. That kindly come to the order of the London Appellate Court. How this was refused. But I am not reading the whole. And last page, 170, 171, 172, 173.
anyway, let us come
173.
to, anyway, this is the impugned order.
Yeah. I will take some time because I will go few lines in title suit 982 of 1997. I am coming later on. But first, your lordships kindly have a look the order impugned.
Yes, Miss Bill 61.
Yes. Your lordships kindly come to last page. Last page. What he praised, no copy of order 13 rule 1 and 2 in this file. The application, the plea which was refused by the court below, that copy was not find place in the application under Article 227. Very much surprising. The plea which has been refused, that copy is not available.
Not to have been filed.
Not filed intentionally.
So have you filed from your side?
No, I have filed nothing because he burdened this.
Yes, so can you file that copy on the next day?
Burdened this court.
I have the copy of.
No, that copy of the trial court's order. Have you filed by way of
Application.
supplementary
Copy of
affidavit?
Trial court's order.
Yes, of refusal.
Application.
No.
Application.
I filed the memorandum of appeal before the trial court.
Anyway,
Appeal court.
question is.
I'm not filed the memo.
Question of, you have to assail both the orders. That is the trial court and the appeal court.
Yes.
What you have relied is the order of the appeal court.
Yes.
So where is that order of the trial court? You have not filed it in.
Yes. Order
Order is there.
Yes.
The application is not there. What we are not in a position to deal with what he praised before the court below. What was his application? He was so much apprehensive. He is so much taking care of the deity. He missed to annexed his plea.
Anyway, plaint is only annexed.
Plaint annex. At the outset, I submitted the only plaint annex. The plea which he made.
Before the appellate court, was this annexed? Appellate court?
We don't know, but here it is not. So I can't answer your lordship that whether I will be prejudiced without seeing the application for temporary injunction or of 13 rule 1 and 2 of the Code of Civil Procedure. How can I answer myself?
So let him file it on the next day.
Intentionally, he has not filed it.
File it on the next day by way of supplementary affidavit.
I conclude my argument.
Let the court see. The court is now in the dark.
Yes,
you have now opened the eyes of the court.
And my lord, another thing, my lord, what is his main motive? Another thing is, my lord, kindly see the last can 8. Whether this sort of prayer.
Can 8 is what?
Can 8 is an application for stay of the proceeding being miscase number 30 of 2024 arising out of ejectment execution case number 151/2023 arising out of ejectment suit 129 pending before court learned second bench small causes court Calcutta. So small causes court Calcutta's proceeding, my learned friend clients wants to stay
without filing a separate proceedings.
My lord.
No. I filed this as separate proceedings.
My lord, whether.
So what is the necessity?
Yes, my lord. Yes.
I shall submit.
Just a minute.
So if I pass any order, it will be abuse of the process.
I know. I have full faith. It is because we are in a high court.
Now you have waited for so long. Just wait for a few days. Let him file the application by way of yes, record an order. Learned advocates for the parties are present. Learned counsel for the petitioner has concluded his submission. Mr. Puddar submits, but also could not conclude his submission and refers to the record there where the application for injunction is not annexed to the main petition, nor is it filed in the nor is it annexed in the supplementary affidavit, which the petitioner has filed. Today you are filing.
Tomorrow, my lord?
No, what have you filed? The supplementary affidavit today?
No.
Oh, we filed supplementary affidavit earlier. So that's an opportunity. Supplementary affidavit which is filed by the petitioner. In the facts and circumstances, the petitioner is granted an opportunity to file a supplementary affidavit by 19/1/2026. Let this matter appear on. আচ্ছা দেখুন তো কবে টাইম আছে? কুড়ি তারিখে 12টার সময় টাইম আছে?
Yes,
10-15 মিনিট।
হ্যাঁ 20 তারিখে 12টার সময়। Okay, 20th January 20th January 2026 at 12 p.m. Yes, Mr. Poddar, on the next day, if possible, you come with your written notes of arguments. Your learned friend has filed written notes, so that another date will not be required to submit written notes of arguments.
Malad, before rising, I say
Yes.
one. Malad, at 2 p.m. Malad, there is a hearing of second appeal fix.
Yes.
Thereafter, your lordship will be taking Malad.
If time permits, then 3 p.m. also there is 3 সময় আছে কি কোনো fix? Anyway, if time permits, okay. If both parties
We
are
shall be waiting.
no. If both sides are present, if time permits, definitely.
If Malad, both sides are not present, your
No.
lordship will not dismiss the
Because you
matter.
see, many have thought that the matters may not be taken up. Huh? No, release up to recess. All matters release up to recess. Anyway, let's see. Okay.
I think this one asked.
আমার তো conclude হয়ে গেছে। আমার তো conclude হয়ে গেছে। তুমি বলবে তো।
I'm for the opposite party.
For judgment item.
দেখিনি আমি করছি।
Yes.
Yes, sir, for petition.
Yes, thus this application under Article 227 of the Constitution of India stands disposed by directing fresh local investigation by special officer in terms of the above observation.
Item number 2 and 3. Lordship beg to appear on behalf of the respondent claimants.
You are for respondent.
Respondent claimants, ma'am.
Yes, hence this appeal being 1048 of 2025 and counter objection COT number 150 of 2025 fails and the same are dismissed. The judgment and award dated 28th February 2025 passed by learned additional district judge 4th court Asansol Paschim Bardhaman in MSc case number 51 of 2017 stands affirmed. However, the direction to pay further interest at the rate of 9% per annum in the event awarded sum is not paid within 30 days is hereby set aside. The respondent number 1, 2 and 3 are permitted to withdraw the awarded sum along with interest at the rate of 6% per annum from the date of filing claim case till date of deposit along with accrued interest after compliance of all necessary formalities. The residuary amount along with accrued interest shall be returned to the appellant insurance company. Yes, call the fixed matter.
But I had concluded my submissions, Lord. Mr. Rai will be making his submission.
Yes.
But I'll only take your lordship's leave, Lord. Mr. Rai will continue, Lord.
Thereafter, you will reply.
Some reply will be required, Lord.
But try to conclude it today because
Yes, I understand, Lord.
because
If
I
I
fixed
for
it.
some
Enough time is
reason or
there
the other
today.
I'm stuck, Lord. Kindly gives me one more date. If for some
Oh, of
reason
course,
or
I
the
shall
other
give you one more date for written notice.
Yes, yes, yes. For that, yeah, grateful.
Yes, please.
Therefore, this is a suit for eviction under the Transfer Property Act. 106 notice was issued, on the basis of which, my lord, an eviction was sought for. I am drawing your lordship's attention what is the case made out or what is the defense taken. My
This
case,
is the case of the plaintiff.
my case is that you are my tenant. I have inducted you.
Tenant under the trans license, lessee.
Lessee. Lessee, my lord, the unregistered lease deed, so it comes with the
Whatever it is, lessee under the Transfer of
Transfer
Property
Property
Act.
Act. Therefore, 15 days notice that has been given on that basis. That your lordship find plaint itself once, as your lordship was. I'll turn to page Yeah. Hmm. Yes. If your lordship may kindly turn to page 92. My lord is
Just. Yes.
পূর্বোক্ত বর্ণনা মতে বাদীর অধীনে নিম্নের ক তফসিল গৃহের বাবদ বিবাদী বাংলা মাস অনুসারে 50 টাকা ভাড়া এবং প্রতি বাংলা মাসের পরবর্তী বাংলা মাসের 15 দিনের মধ্যে রসিদমূল্য আদায় দিবার নিয়মে অস্থায়ী স্বেচ্ছাধীনের মাসিক ভাড়াটিয়া হিসেবে দখল করিতে থাকেন এবং বাটির খরিদের পর থেকে পুরোনোদের মালিকের নিকট বাদীর ক তফসিল গৃহের বাবদ যে ভাড়া বাকি ছিল সেই ভাড়া বিবাদীকে রসিদ মূল্যে আদায় দিয়াছে। বিবাদীর নালিশি ক তফসিল ঘরে মিষ্টির দোকান রইয়াছে। মাই লর্ড কাইন্ডলি রেকর্ড দ্যাট মিষ্টির দোকান রইয়াছে এবং বিবাদী বাদীকে এত নিম্নের ক তফসিল বর্ণনার বাবদ ভাড়া রসিদ মূল্যে আদায় দিয়াছে এবং তৎপরে বাদীকে পুনঃ বিবাদী ইচ্ছাপূর্বক এত সালে আশ্বিন মাসে ভাড়া টাকা আদায় না দিয়া বাকি ফেলিয়াছে।
This is your case.
This is my case. So only one thing I want to draw attention, what is the nature of user? মিষ্টির দোকান। After that, my lord, may তফসিল ঘরের দাসপুর থানার অন্তর্গত অবস্থিত বিবাদী তার দোকানের মনে মিষ্টান্ন ঘরের মধ্যে উনানের আগুন ও ধোঁয়ায় ক তফসিল বর্ণিত ঘরে প্রভূত ক্ষতি হইতেছে এবং উক্ত ঘর বাদী নিজে প্রয়োজনে খাস দখল আনয়ন করার আবশ্যকতা দেখা দিয়েছে। বাদী নালিশি ক তফসিল ঘর হইতে উচ্ছেদযোগ্য থাকায় ক তফসিল বর্ণিত গৃহ হইতে বিবাদীকে উচ্ছেদ মতে এবং খাস দখল পাইবার জন্য বাদী তাহার নিযুক্ত অ্যাডভোকেট বিশ্বনাথ রায়ের মাধ্যমে ট্রান্সপোর্টেশন 6 নম্বর তার মতে উচ্ছেদের নোটিশ ইংরেজি এত তারিখে রেজিস্ট্রি জাগযোগে এটি বিবাদীর নিকট প্রেরণ করেছে এবং রাধাকান্তপুর পোস্ট অফিসে পোস্টাল পিয়ন বিবাদী হারাধন রায় ও হারু ওরফে হারু হাজরাকে এত তারিখে তার রেজিস্ট্রি দিতে যায় এবং উক্ত রেজিস্ট্রি কাম বিবাদীকে টেন্ডার করে তা গ্রহণ করিতে বলে, কিন্তু বিবাদী ইচ্ছা করে উচ্ছেদের নোটিশ রেজিস্ট্রি কাম গ্রহণ করিতে অস্বীকার করায় সংশ্লিষ্ট পোস্টাল পিয়ন রেজিস্ট্রি রিফিউজ ফর্মার্থে এত তারিখে দিয়া ফেরত দিয়েছে। So this is the crux of my case. Now my lord can you consider how the defendant's positive case. Now my lord has considered the pleadings of both the parties. The second appeal. Now my lord, if your lordship can turn to the case which was made out. Yes. And turn to page 116.
Yes.
Paragraph 18, if your lordship can turn to paragraph 18.
Yes.
অধীন মিষ্টির দোকান করিবার জন্য মাইলার গট ইট মাইলার প্রবলি ইট ওয়াজ
Para 18, yes.
Yes. অনুমতি প্রার্থনা করিলে উক্ত সমন্বয় দত্ত তৎকালে উক্ত খালি ভূমির উপর অধিকৃত প্রস্তুত করিয়া লইতে হইলে তাহাতে ভাড়াটিয়া হিসেবে দখল করিতে পারিবে।
Para 18, page 116.
Yes, my lord, page 116.
Yes, প্রকৃত বিবরণ।
Yes, yes, because there is a, I am not on that they said some portion of the construction is within the suit property, some is the PWD land, so I am not be evicted from the land which belongs to PWD. That was not been considered by both the courts, and ultimately no issues of to that aspect also. But the positive case is that তৎকালীন মালিক সমরেন্দ্র দত্ত দিগরের, my lord will find it is fourth line from the bottom, my lord will find from the middle portion it starts.
No, actually, you see, when some property is being occupied, and for that occupation, some occupation charge is paid. So then there is a Supreme Court judgment that landlord-tenant relationship cannot be disputed.
Yes, that is why it is there is no dispute. That is what precisely, my lord. Now I have to satisfy your lordship that the notice is valid. In what defense they have taken, how they have stick, because preponderance probability, my lord.
What is the question of law?
Yes,
framed by the division?
Yes, that I'll come to. That is
That the submission is.
yes. Now, my lord, can you consider paragraph 18 because this is the defense. That after that I'll come to that, my lord. This is a specific case made out. দোকানদারের জন্য উক্ত সম্পাদনাদিগয়ের নিকট অনুমতি প্রার্থনা করিলে উক্ত সম্পাদনাদিগ তৎপরে খালি ভূমি অধিগৃহীত উপর অধিগৃহ প্রস্তুত করিয়া লইয়া তাহাতে ভাড়াটে হিসেবে দখল করিতে পারিবে এবং এমতো ভাড়া আদায় দিতে হইবে। এইরূপ প্রস্তাব দেয় অধীন বিবাদীর সহিত তৎকালীন মালিক সমাধানাধিকারের মৌখিক চুক্তি হয় যে অধীন নালিশের সম্পত্তির উপর নিজ খরচা গৃহ প্রস্তুত করিয়া লইবে এবং সমাধানদত্ত দিগের অধীনে স্থায়ী ভাড়াটে হিসেবে মাস মাস ভাড়ার টাকা আদায় দিয়া রসিদ সংগ্রহ করিবে। যেহেতু অধীন বাড়ি নিজ অর্থে গৃহ প্রস্তুত করিয়া রয়েছে সেহেতু সম্পত্তির বিবাদীকে কোনো মতে উচ্ছেদ করা যাইবে না। অধীন ক তহসিল প্রেমাইসের পার্মানেন্ট টেনেন্ট বা স্থায়ী ভাড়াটে হিসেবে দখল করিতে আসিতে থাকিবে। উক্ত প্রকার চুক্তি মতো নালিশের খালি তহসিল প্রেমিসেস খানি নিজ অর্থে প্রস্তুত করিয়া তাহাতে বড় বড় ভাড়াটে হিসেবে দখল করিয়া আসিতেছেন আসিতেছে। ক তহসিল প্রেমিসেস বাবদ চুক্তি মাসিক 45 টাকা প্রতি মাস অনুসারে ধারাবার্য রইয়াছে। অধীন এত 14,000 মাত্র ভাড়াটিয়া সমাধানকে আদায় দিয়া 1 নভেম্বর তারিখ হতে রসিদপ্রাপ্ত হইয়াছে। উক্ত সমাধান দত্ত কতিপয় তহসিল খানি বাদী বিক্রয় করিয়াছেন কিনা তা বিষয়ে অধিক কোনোভাবে জানান নাই। অধীন সমাধান দত্তকে বাড়ি ভাড়া আদায় দিতে গেলে তিনি তা গ্রহণ করেন নাই। উপরোক্ত বর্ণমতে কতশীল প্রেমিসেস খানি বাদী নিজ অর্থে প্রদান এবং তৈরি করিয়া তথায় মিষ্টির দোকান করিয়া তাহাতে চালাইয়া আসিতেছে। উক্ত কতশীল প্রেমিসেস খানি দক্ষিণ অংশে কিয়দংশে পিডব্লিউডি ভূমির উপর নির্মিত হইয়াছে, অর্থাৎ কতশীল মধ্যে ঘরের এক অংশে পিডব্লিউ রাস্তার উপর অবস্থিত হয়েছে, সুতরাং ওই অংশ বাদী বাদী আদৌ কোনো রকম অংশীদার নয়, মানে অচল ও ডিসমিস যোগ্য হইতেছে। Now the specific case, this is the paragraph 21. এই বিবাদী আর নিবেদন করে যে বাদীর কথিত ট্রান্সফার প্রপার্টি অ্যাক্টের 106 ধারা মতে নোটিশ এই বিবাদী উপরে আদৌ জারি হয় নাই বা উক্ত নোটিশ এই বিবাদীকে এত তারিখে বা কোনো তারিখে রাধিকান্ত পোস্ট অফিস আদৌ টেন্ডার করেন নাই বা ওই তারিখে এই বিবাদী আদৌ রাধিকান্ত থাকেন নাই। So this is the specific defense taken, my lord. Now apropos to this, my lord, when you turn to the trial court judgment, I am drawing lordship's attention only the issues frame that your lordship will find at page 5 of the paper book.
Yes, page 5.
I got it. These are the issues framed.
Yes.
Issues number 3 and 5, subject to question, are the issues which require to be considered.
Yes.
Now, my lord, can you turn to three? That is at page 9. Your lordship, can you turn to page 9?
Yes.
Page 9, last line, my lord. I am reading Sobita Roy and Anita Rani Sarkar, my lord, got it. Last line, my lord, because these are the how the
Yes.
for permitting him to construct a house upon the vacant portion of their properties to run a sweet shop. They permitted him to construct a house on condition that they would possess the cost schedule as a monthly tenant under them a monthly rent of rupees such as such. When no documents have been produced by the defendants to prove the same, it appears from Exhibit 14. The defendant has admitted the plaintiff is the landlord of the suit premises. Therefore, in view of the aforesaid facts and circumstances, it can be safely held plaintiff is the owner of the suit property. Hence, the instant issue decided in favor of the plaintiff. Because I produced the deed, which is the admitted owner, from whom I have purchased, the case made out by the defendant has failed to prove that he has, be as it may, my lord, if the construction for the abandoned construction, my lord, are making this submission. Even then also, this does not mean permanent tenancy is available in West Bengal. Subject to question, this is a construction made based on license, my lord. It is under the Easement Act, which has no applications over the Bengal and Assam, because it is not been adopted by notifications about the Bengal is concerned. So that is immaterial. We are not going to that. He unable to prove the same, and that is not the case because it came to conclusion that unable to what case you have made out in the pleadings not been proved.
Anyway, the tenant also cannot dispute the owner landlord-tenant relationship.
They want to make that case on the basis of that concept that construction made based on license is irrevocable tenancy. But that is not applicable in Bengal. Now, can you turn to paragraph 5? This is the issue which you got to be issue number 5, page 11. Well, got it. Then it stated that he has sent a notice of eviction to such and such. On perusal of exhibit 14, I find that the plaintiff had served a notice dated 23rd July 2006 through his learned advocate, Mr. Vishwanath Roy, though the defendants have denied the service of notice by stating their father, Haradon Haru, did not refuse to accept the notice of eviction on such and such as the same was not tendered to him by the postal peon. It is further submitted the defendant, their father, Haradon Haru, was not present in the suit premises, but he has gone to the father-in-law's house and he was there since till Savon 1413 BS. However, no document has been filed by the defendants to prove the same. On perusal of exhibit 12, it appears the defendant's father, Haradon, refused to accept the said notice and the endorsement on the envelope as refused was written by the postal peon. Now the question is whether in view of section 14, it can be said the notice was properly served upon the defendant. If I ignore the exhibit 14, that the notice was properly addressed, in the case of such and such, my lord, I am skipping over the judgment. The difficulty where the postman called at the address mentioned and was unable to contact the addressee or a person authorized to receive the letter. In this circumstance, the postman returned to the Sodor. Honorable Apex could also observe that the Indian Post Office rules did not prescribe any detailed procedure regarding the delivery of such registered letters. When the postman is unable to deliver it to the first visit, the general practice is that the postman attempts to deliver the next 1 or 2 days also before returning to the sender. However, he has neither power nor the time to make inquiries regarding the whereabouts the addressee. He is not expected to detain the letter until the addressee chooses to return or accept it. The postman is not authorized to affix the letter on the premises because of the addressee's absence. His responsibility cannot therefore be equated those of a process server entrusted with the responsibility of serving summons under Order 5 of the Code of Civil Procedure. The Honorable Apex Court observed all that the landlord could do is post a prepaid registered letter, acknowledgement due, otherwise containing the tenant's correct address. Once the landlord does this and letter was delivered to the post office, he has no control over it. It has been presumed that the service is delivered to the addressee under section 27 of the General Clauses Act. I've gone through the copy of the notice such and such, and the defendant's father Haradon as the tenant of the suit premises. Mark for eviction also been properly identified the suit premises. In the schedule of the notice, this clearly conveys the intention of the landlord to terminate the tenancy. The tenancy also contains the threat to sue in default of compliance with the terms of the notice. It transfers from Exhibit 9 the written statement that the defendant was a monthly tenant and that the plaintiff monthly rent was settled from very beginning. I think that a clear 15 days notice should be valid. However, in a notice under Section 106 of the Calcutta Act, one requirement is to fulfill should get 15 days notice. In the instant case, the suit notice was sent on 23rd July 2006 and it has given more than 15 days notice to vacate. So the requirement under 106 of the Transport Act is fulfilled. Though it is not required to give notice expiring the month of tenancy under the Transport Act, but the plaintiff has given the notice expiring the month of August. And as such, it can be held that plaintiff has complied with all formalities, so I have no hesitation to hold the notice was legal, valid, and properly served upon the defendant. So this was the premises for the trial court for holding the notice is good. The appeal court also accepted the same. Now, my lord, on the premises, what is the substantial question of law framed? If your lordship may turn to page 61. My lord, got it.
Yes, 61.
Whether, my lord, it is not the notice is bad. What has been said, my lord, can you consider whether the learned courts below applied the proper legal test in determining whether the notice under section 106 of the Transport Act was properly served by the respondents upon the appellant.
So this is the law formulated.
Law formulated. So whether the service as satisfied by the learned courts below is valid in the eye of law.
Yes.
Now, if your lordship may kindly consider the appeals court judgment on the part of the only I am drawing also is the notice itself. That your lordship will find at page.
Yes, that
It
is.
starts from 24. I am drawing lordship attention.
So this is the formulation of the law.
Yes, whether service has been duly effected. Now, I have filed the receipts copy of the registered post. The envelope returned with the endorsement refused, and the postmaster was examined along with the postal peon who have tendered. My lord, the lordship will not
Now the
find.
question is, you see, first of all, genuine refusal is a good service.
Yes.
That is the thing. So if there is a refusal which is proved, then it is a good service. Now whether that refusal was genuine or it is in collusion.
It is done by. So this was the question to be considered.
Yes.
Now, for that purpose, what I have to do? I have to bring the person who is accounted regarding the service of the postmaster and the peon who have tendered the envelope was summoned.
The authority who was entrusted with the for
Yes.
causing service.
Causing service, the postal peon and also the postmaster.
Yes.
This is the postmaster, my lord, and this is the postal peon. PW3, I have handed over to your lordship, my lord. Probably it is copies.
Anyway, I'm just going through the, in the paper book it is not there.
It is not there. That is why.
Anyway,
I have handed over to you. LCR আছে কিন্তু নামে
and the trial court has discussed this issue regarding service.
Yes, that is issue number 5.
No, issue number 5, you see that whether the learned trial court has discussed that the postal authorities were examined.
Trial court is proceeded on the basis of the fact that you have denied that you are not present and you are not been tendered.
So whether that denial endorsement, okay, is genuine or not, for that evidence has to be adduced.
That evidence is there in the records.
So whether that there is any discussion with that.
In that, I do not find any such discussion by issue number 5.
Number 5, okay.
That is the only issue. Now my lord has
not refused to, as the same was not okay. Has been filed by the defendants to prove the same. Anyway, but it's not that the defendants who are to file that you were not there or that refusal was in collusion. So for that, examination of the postal authority.
Yes, it was there.
No, in which paragraph the learned court has discussed that the.
No, it has not discussed with the learned trial court. That is why, my lord, the learned trial court proceeded on the basis of the fact, being a landlord, what steps you are required to be taken. Under the statute, postal receipts, proper address, and return with the endorsement refused. Under the clause 1 of the Supreme Court has said, I'll draw to your lordship over those judgments, that these are the things. Now the defendant, if the defendant has any objection that he was not there, the refusal was not by.
Okay, now exhibit 11 series was considered.
Yes.
That the notice was properly addressed.
Yes.
So when is that?
11th
series was what?
Yes, my lord, if your lordship kindly consider page 7 of the paper book.
One is examination and that is the exhibit series. Okay, exhibit series is
page 7, my lord will find.
Page 7 of your
paper book.
violation.
No,
Okay.
paper book. The exhibits lists are there mentioned.
Exhibit 11 series. Then page 7.
Page 7.
Yes. Okay, sir. This is the computerized.
Exhibit 10 is the postal receipt. My lord will find.
Yes.
Exhibit 11 is the envelope along with ID card.
No, did you serve by both registered and UCP under certificate of
No,
posting?
registered post.
See, if UCP, if you serve, then also there is a
Yes,
proof.
but that is.
But if he is not available also, that will
returned.
be in his house. No, under certificate of posting, it will be in his
house. That will not suffice the
because that will not come to you.
No, but here, my lord, it has returned to me and I have produced. It is registered post is acknowledgement due. My lord knows under the post office rules, speed post is to the address, but registered post to the addressee. This is the distinction between these two services. So the registered post belongs to the addressee. It was addressed to the addressee and the addressee who is alone.
It was attempted to be served.
Yes.
No, in speed post also,
No,
there is a track report you see that delivered to the addressee.
No, address is sometimes in somebody else because it is to the address. Under the post office rules, these are
track report. It is stated that delivered to the
item delivered. Now, my lord will find item delivered.
item delivered to the addressee.
Addressee, but the post office rules, because there is speed post, there is a specific time frame has been given by under the rules that you have to serve to the address. That is why the post office rule says the speed post to
And
the
acknowledgement is also taken.
Yes, that it has been delivered to the address, but
with an acknowledgement.
Yes, but registered post is to the addressee, the person. That is why your lordship will find.
Yes, envelope, AD card, refused.
Yes.
Yes, so issue number 5 is
whether the notice duly served and valid in the eye of
Exhibit 11 series.
Yes, the
envelope with the AD card.
AD card.
And then the remark is refused. So this was exhibited, this remark, refused remark was exhibited by examining the postal authority.
Yes, peon is there.
Yes.
Peon's evidence is there. Postmaster and peon.
Okay. So after perusing 12, witness identified his handwriting, refused and returned to the sender. Yes. This is the postmaster.
Postmaster.
This is the postmaster.
Next page is the
handwriting into refused and returned to sender. No, postmaster's remark, refused and returned.
No, it is a postal peon, my lord. Next is the
No, Amar Chaudhuri.
Amar Chaudhuri is the postmaster.
I'm a postmaster.
Next is the postal peon.
Yes, next is
the peon.
Okay. This is also marked exhibit.
Yes. This is my handwriting. I put my signature. I have tendered this document, and it was refused. And Manakali is considered what are the cross-examination?
Letter was written by. Yes.
Malakali, consider what are the questions put forward in the cross-examination?
Yes, different questions are there.
Not, you are not there, you did not serve. Any suggestion to that effect to the postal peon? Subject to question, my lord?
No.
Then, if your lordship kindly consider the Carapet's case, my lord has enough experience over considering the same. If any vital question was not put to the in cross-examination amounts to admission on the part of the because he is the person who can say, yes, I did not went there. You are not there. You are out of station. He did not meet with me. No question put forward in cross examination. No suggestion has been given.
Yes.
Now, if your lordship can consider the appeals court finding regarding the service of notice. That your lordship will find at page . Word number 3 and 4. Word number 3 and 4. One. Now, can you turn to point number 1 that your lordship will find? It starts on page 32.
Yes. Yes.
Well, I got it. Whenever the appellant has asserted that the notice is an incomplete one and it does not state about the termination of tenancy, the appellant submitted that the language of the notice marked exit 14 is not proper and for which such cannot be construed as being a notice effective enough to terminate the tenancy.
It is which paragraph?
My lord, it starts 1.1, your lordship will find.
Yes.
The question has been framed. And after that, the findings of the
law formulated, question formulated is whether service was affected.
This is the only thing.
And the notice regarding the notice, there is no such formulation of law.
Apart from that, the veracity of the notice was not being challenged by the defendant also. Whether the notice of 15 days is valid or invalid or not. It is the specific case of the defendant that no notice was served upon me. I am a tenant. For running a suite meets of a tenancy was obtained and no notice was served upon me. This is the sum and substance in their defense.
Yes.
However, the appellants assert that the notice is an incomplete one as it does not state about the termination of tenancy. Lana advocate for the appellant submitted the language in notice marked exit 14 is not proper and for which such cannot be construed being the notice effective enough to terminate the tenancy. Section 106 of the Transport Property Act only states about the period prior to termination and that such notice must be in writing, signed by on behalf of the person giving it, the mode in which such notice to be tendered and delivered. The language of section 106 do not state that the notice must be in any predetermined and prescribed format. A notice shall be deemed sufficient if it unfolds the intent behind such notice and conveys such intent unequivocally to the person addressed in clear terms. On perusal of exit 14, it appears the notice stated in clear terms that the tenant was to hand over possession of the tenanted room on the first day Bhadra 1413 BS and from such date the tenant shall register as a trespasser to such room. Therefore, the very reason for which such notice was being served has been stated through the words in clear terms. On perusal of the impugned judgment, it appears learned Service Civil Judge Junior Division. Ghatal has scrutinized the contents of the notice and currently ready with the conclusion that the notice justifies the defendant's further the grounds for eviction also properly identify the suit property. The Darling Tribunal also clearly held the statutory time period given to the tenant was actually given by the plaintiff through the said notice. Therefore, I hold that the Subdivisional Civil Judge Junior Division Ghatal has rightly held the notice was legal and valid. In all formalities, such notice has been complied with. Hence, the plea of appellant that the notice is lacking and incomplete cannot be a ground. Next is, I look into the question as to proper service. My lord, which is the formulation of the question by this honorable court also. Question of the proper service of notice. The learned for the appellant had vehemently stressed upon the issue as to proper service of notice. The notice as was sent to the original tenant had been received back with the endorsement refused. It is the plea of the appellant that such endorsement was the result of an act of collusion with the postal peon. The learned of the appellant has asserted that the endorsement was only a table work. The registered envelope containing the notice was never tendered to the original tenant. The first ground taken up by the appellant in his effort to prove the alleged collusion is that the person addressed, namely Haradhan Haruhaza, was not present at the given address, but he had gone to his father-in-law house, and for which there was no manner in which the notice could have been tendered to him the address stated in the envelope, and consequently there is no question of refusal. Such a plea was also taken before the learned trial court, and the learned trial judge disbelieved such plea, stating that no documents in support of his plea was filed. And what the appellant asserts, if a person goes to visit in his law's house, then in also there would be no document to support the fact of unless this travel is undertaken through rail or airways. On perusal of the written statement, it appears Haradhan Haza asserts that on 15/7/2006 he was not Radhikantapur and he used to reside in Chakubulia Gram at his father-in-law's house from Ashar 1413 BS to the month of Savana, such and such. Division 1 also asserts in her examination in chief, while in the written statement it has been stated Haradhan that he had went to reside at his in-laws' house for his family reason. Yet DW1 stated during cross-examination that Haradhan Haza has visited in his law as per her parent were ill and not doing well. DW1 strange enough that she does not know what was the illness of her parents. The witness says the doctor had visited her house and prescriptions were issued. Neither the doctor nor the prescription find place within the evidence of adduced by DW2. DW2 Madan Hajar also stated in examination in chief that due to some family problems, Haradhan Hajar has resided at his in-laws' house for 2 months, Asar to Shravan. During cross-examination, he stated that Haradhan was his full-blooded brother and his Bodhi had accompanied him at the time when the written examination in chief was drafted. The witnesses further stated that he does not know what is the written in the examination in chief, and that is his Bodhi who knows better what was written in his examination in chief. Therefore, the evidence DW2 cannot be relied upon. He also stated it is not possible for him to state about the whereabouts of his brother Haradhan on such and such, and he cannot tell whether on such and such the postal bearer tendered the registered envelope to his brother Haradhan or not. DW3 Dhananjay Manna stated in his examination in chief that Haru Haza, for his family problem, had resided in his lodge house for 2 months, ranging from Ashar to Shravan. During cross-examination, the witness said he does not keep track movement of Haradhan Haza as to when he goes to his daughter's house or his father's house or in-law's house. The witness did not state if the shop of the said Haradhan is closed for longer period of the time. He inquires about the whereabouts. Last year, he had asked Bharti Dinda about the defendant's whereabouts, and it was told that the defendant has gone to his father-in-law's house. Such statement had no evidence value, and such witness spoke of last year. The witness also.
Question is, it is not a residential house. It is just a business establishment.
Yes.
So the question you see whether it is not residence come business. Only for business purpose.
Only for business, commercial activities for running a sweetmeat shop.
So now the question is whether evidence was there during his absence, whether the shop was closed or not.
That is why, precisely it was there. The question was put forward that witness did not state. My lord will find page 35, last 4 lines. That if the shop of the said Haradhan is closed for longer period of time, he inquires about the whereabouts, and last year he had asked Bharati. So this is the contradiction court is of the opinion. Why we are saying last year? Must be that year. That is why, my lord. And he had asked Bharati Dinda about the defendant's whereabouts. And it was told that the defendant has gone to his father-in-law's house. Such statements have no evidence value. As such, the witness spoke of last year. The witness also could not state when his son goes to his father-in-law's house and decides where he returns. Therefore, it appears such a witness cannot be relied upon. DW4 Harukor also stated in examination chief, due to family problem, Haru Raja resides at his in-laws' house from month of Ashar 1413 to Savan. During cross-examination, the witness stated that his examination chief was written after discussion with Balaram, and that he had come to court along with other witnesses prior to his deposition. But this is very important. So, who has given the instruction? The Balaram. Here appears the seven assertion that Haru Haja was not at the address as mentioned in the envelope on the date mentioned. There is not a single evidence, be it oral or documentary, which can lend support to such assertion. Hence, I find myself consonance with the conclusion arrived at the subdivision Judge Junior Division and stating there is no document has been filed by defendant to prove the said case. Next, the learned advocate for the appellant also submitted that the plaintiff.
No, any employee of the shop examined that the shop was running.
No, nothing. Nothing. These are the four witnesses. What you have done for that 2 months, whether who was running the shop, if the shop was open or not, nothing to that respect.
No, the persons who have deposed are the relations of this person.
Yes, because
or local.
Yes, because they are the person who have been guided on by the Balaram.
Yes.
The learned advocate for the appellant has also submitted that the plaintiff, while deposing PW1, has stated that the postal peon had made an endorsement and refused and returned to the sender in its presence, for which such being forth ample proof about the assertion collusion. I am not in consonance with such line of assertion for two reasons. The first being this court cannot rule out the probability that the landlord was present at the premises when the notice of eviction was tendered. The second being that such a stress statement is not sufficient enough to hold the favor of the alleged collusion. The argument for the appellant has asserted that the suit property is a Radha Krishnapur Moja, while the defendant Haruvaja is a resident of Radhakantapur. Therefore, it is beyond the comprehension and how the defendant was found to be present residential house and not at the shop room. It appears such a also defense without any weight whatsoever. Because if that be the case, my lord, it is contrary to his own assertion. It is not the case. I am not at that relevant point. I am not there in the house or the shop room.
No, question is, you see, he was in his in-laws' house. It's not a case that person not residing in his residence, residing in in-laws.
Yes.
But this is with regard to his residence is not this one. It is only his shop room.
Shop room.
Is the residence in that locality any evidence?
Yes, that is why already it is. The learned advocate for the appellant has asserted the suit property is at Radhakantapur Moja, while the defendant Haru Hazra was a resident of Radhakantapur, and therefore it is beyond comprehension how the defendant was found to be present at his residential house and not at his shop room. It appears such also a defense without any weight whatsoever. Because it is his case that I am not there at all. It is a locality, my lord. Radhakantapur Moja, it is there, and the shop is there. I could have understood it is said I am not at the relevant point of time, I am not in the residence, I am in the shop room, it has not been tendered to me. It is a specific case, I was not there. My lord has to consider it that way, that which the defense has taken. Defense is that I was not there in the place itself. I am went to my in-laws' house for last 2 months. So whether he was in shop or in residential house, it is immaterial to discuss. It is his positive case. My lord knows the burden of proof. It is a positive case. It is his positive case that I was not there. I am out of station.
In the shop room.
Not even the shop room, not at the locality. He said I used to stay at my in-laws' house.
And the question is, a person may stay in the in-laws' house, but for the purpose of business, he may come to his business.
That is what is following from a What is any to that aspect? Whether any pleadings to that effect?
Yes.
That is why, my lord, I have drawn to your lordship. This is the written statement. What is the difference?
Person may stay in the in-laws' house, but this is a shop room. There is no bar to come.
That is why what is following from is a pertinent question. Then whether the shop was closed, whether any
no evidence that the shop was closed.
Or the employee came forward to adduce evidence that yes, the shop was closed, or by staying somewhere else. The defense case is only based upon the fact no notice was tendered to him. He was out of station.
Yes, no notice.
Out of station.
The remark was in collusion.
Yes.
And now the question is, this collusion means the postal authority examined.
What is the question in the cross? What are the questions put forward?
And the other thing is this, substantiate his case, he has adduced that he was in his in-laws' house. That is the oral evidence.
Oral evidence. Apart from that, it was also mentioned by the person who has given evidence that we do not have any direct knowledge and consult with somebody else. This evidence chief was prepared, DW4. And others said, I do not have any direct knowledge about this. I came with the Bodhi. Bodhi is nothing, the wife of Haru. So how this evidence can be considered in that aspect? Because the cause for went to the in-laws house also could not be proved. Because in his register, he said, due to some personal difficulty, I went there. The Bodhi come forward and in her evidence said her father was ill. That is why we went to in-laws' house. But nothing has been proved for the illness of the father.
The place of in-laws' house is mentioned.
May you repeat it?
Place.
Place. Testimony. Yes, yes. কোথায়? পরেরটা? Yes, my lord. ওই দেখ রিটেন স্টেটমেন্টে বলা আছে আমি কোথায় গিয়েছিলাম। My lord, can you turn to 119? এই বিবাদী পারিবারিক অসুবিধার কারণে my lord got it 119
yes
অসুবিধার কারণে 1413 সালের আষাঢ় মাস হইতে শ্রাবণ মাসের সংক্রান্তি পর্যন্ত 2 মাস চকবোয়ালিয়া গ্রামে শ্বশুর বাড়িতে বসবাস করিতেছিলাম।
Yes. But there is no specific evidence that during that time he did not come to this shop.
Yes. Even if we are unable to prove that he at all went that place or not.
Now, suppose the thing is this, when he goes there, save and accept the oral evidence, there is no.
Nothing.
And oral evidence will be either his own relations or the in-laws.
In-laws. In-laws did not come forward.
Whatever it is, there is no other, there cannot be any documentary evidence.
Documentary evidence will come if it appears, because the evidence of Bodhi is that due to, I'll satisfy Lordship, that due to my father's illness, we have been called upon and we went to that. Next question was put forward whether there is prescription to that effect, what was the illness? Bodhi unable to say what type of illness is there. Therefore, the statement or the cause as cited by the defendant to stay abroad or stay out of station.
You see, a person was not in the house, if he says, that cannot be proved. Suppose you are not in the house, you cannot prove that.
Cannot be proved, but my positive case can be proved.
Yes, negative case, you are not in your house.
I cannot
Somebody else has to prove, yes, he saw you in your house.
So I have to prove my positive case. What is my positive case? I put this to myself. I was out of station. I resign. For last 2 months, I am
That
there.
is a positive case.
That is the positive case, the defendant.
So that will imply that you were not here.
Yes.
Now the second question is, even if you are there, whether the shop was closed.
That is
or whether the employees came.
That is the latter portion. What is followed by Lordship, my lord, is going to that extent. The positive case of the defendant, I was not there, I was staying. The positive case is that I was staying somewhere else. That will ipso facto shift the burden onus upon me to prove that yes, you are there.
The documentary proof is this report and his examination.
Examination. And the postal period, my lord, what more I can substantiate? The postal peon, what is the question cross-examination? The collision alleged, whether any question was put forward to the postal peon, nothing.
Yes, this is so far with regard to the service of the notice. One is with regard to the validity of the notice,
Notice
the other
and-
with regard to the service of
Service
the
of the
notice. That is the formulated question, service of the notice. Yes. So the judgments which you relied upon is with regard to what? Anyway, you will give a compilation in your written notes.
The argument from the bar was advanced, if I am not wrong, that the tenancy was taken for manufacturing purpose, for manufacturing of sweetmeat in the shop room, so it will be
There is no tenancy agreement.
no tenancy agreement. So it is for the
No,
manufacturing.
is it a ground or in the written statement?
That is what paragraph 18. Nothing.
Paragraph
18 of the review statement that your lordship will find at page 116.
Now, the only question which remains to be considered is whether the sweetmeat shop
Comes
is
with
a,
the purview of manufacturing unit.
is a question of law, purely a question of law.
That I have also produced the judgment with the honorable court that if you logically consider 106
So
of
that is not formulated. You see,
it is not formulated, not pleaded.
not formulated, but yes, not pleaded also.
No evidence adduced. No issues were framed. It is from the bar for the first time, but I want to meet that same as your lordship was pleased to put this question on the earlier occasion. What is the effect of running a sweetmeat shop which comes with the purview of manufacturing unit? No.
Yeah.
So it is a shop under the shops and establishment.
That is what, well, predominantly, my lord, will find 106, the word mentioned, language used under section 106 of the 2040
So it
Act.
comes under it comes under 106 proviso.
Proviso. Or otherwise, only for manufacturing unit, 6 months.
No, that is the notice is not sufficient notice.
Yes.
Valid and sufficient notice. That is, it comes under the proviso to 106.
Grateful to your lordship.
That it is a manufacturing concern.
Beg your pardon.
That it is a manufacturing concern.
Yes, my lord. Now it is considered by this honorable court. It is a commercial establishment. My lord will consider sweetmeats as a commercial establishment. That was, my lord, I have handed over to your judgment before your lord, to your lordship, my lord, on the earlier question, AI 1954, Calcutta 224.
Yes.
First one, my lord, first one, my lord will find.
Yes. P.N. Mukherjee.
Justice P.N. Mukherjee's judgment.
Yes.
Paragraph 6.
Yes.
Paragraph 5, my lord. My lord, apropos to this, my lord, can you consider মিষ্টির দোকান চালাইবার জন্য, my lord, your lordship will find in the paragraph 18, this is the specific stand taken, মিষ্টির দোকান চালাইবার. There is no dispute that the tenancy was taken for running a sweetmeat shop under the name such and such. There is no dispute that disputed premises comprise entirely a shop room, a kitchen, and a veranda. The appellant contended that the kitchen was taken for the purpose of preparing sweets for sale in the bigger shop room, which is together with the veranda comprised, practically speaking, the one part of the tenancy, and is argued that from the purpose of the tenancy and at least its primary purpose, or at least its primary purpose was to prepare or to use the word so often repeated by appellants, learned advocate to manufacture sweets for sale, and accordingly the tenancy was manufacturing purpose.
That means sweets prepared
and
produced and sold.
Sold.
But there is another decision relied upon by your learned friend, that is food processing industry.
That came up for consideration of the Honorable Apex Court.
Food processing industry.
Yes. That was came up for.
So question is merely if in your residence also if you prepare some sweets, whether that will be a.
Then my lord kindly consider whether a restaurant will come under the manufacturing unit. I put this question to myself.
There are many preparation of food.
Not only one type.
Variety.
Varieties of. That's the honorable. That is what precisely my lord.
Processing industry.
That is machines, labor, and precisely for that purpose the tenancy was obtained.
Only for processing purpose.
Processing purpose. Manufacturing purpose.
The question is this plea and this evidence was not adduced.
Not adduced. Whether in the second appeal, my lord is concerning my lord is exercising power under section 100.
If the point is not raised before
Raised
the
before
Calcutta,
the
no
court
evidence adduced.
Grateful to your lordship. And that is why, in my opinion, in view of the lower appellate court, is right. The use of word manufacture to describe the process or preparation of speaking, not unknown, is generally to hold that a general rule preparation sweetmeats should answer the test of manufacture for the purpose of section 106 of the Transfer of Property Act. Normally it does not, and the present case is no exception. There can no doubt that whenever meaning the word manufacture may be, the present lease was at least as much for sale of sweetmeats as for preparing of the same in the disputed premises.
There is para 5.
Para 5. It is a continuation of para 5, my lord. After the 6.
Yes.
Paragraph 7, what is followed from your lordship, that was precisely. I may point out further, if appellant present contention be accepted, then practically even tea shop or restaurant or hotel would become the tenancy of manufacturing purpose. What is followed from your lordship?
That is even in your residence, if you prepare some sweets or singara, that will be a
manufacturing purpose.
Yes, that is paragraph 7. Anyway, now the factual aspect is this: no evidence was adduced.
Nothing, no prayer, no in the defense, but whatever the evidence will come if there is a pleadings.
Pleadings, and then yes.
If in absence of any pleadings, my lord not go into any sort of evidence. Where is the pleadings? I put this question to myself. And my learned friend also on the earlier occasion said that preparation of this articles comes within the purview of manufacture. That squarely came up for consideration before the Honorable Apex Court, where reported in 1980 Supreme Court page 86, where considering the word manufacture, the Honorable Apex Court said, but not only paragraph 11, before parting with this judgment, we may sound to note a caution that definition of manufacture given in other enactments, such as in Factories Act or Excise Act, should not be blindly applied while interpreting expression manufacturing purpose in section 106 of the Transfer of Property Act. In some enactment, for instance, in Excise Act, the term manufacture has been given an extended meaning by including its repairs also. So it is not a fact that what is manufactured said in other statute we consider to be manufactured.
Yes, the scope of a particular statute has to be seen. What is manufacturing for this statute may not be for other
paragraph 11, the Supreme Court has said. Last paragraph 11, my lord, that is the precisely the law declared by the Honorable Apex. So therefore, in other statute it was mentioned that this running of preparation of sweet meat comes in the purview of manufacture, then also it cannot qualify the terms of 106.
Yes. So these are the 2 points argued, and the question of law formulated is whether there was service of the notice.
So whether, my lord,
that is the point formulated, and with regard to the other issue, although argued, but that point is not formulated, no evidence.
Even if he argued, that is why in reply I have submitted before your
No,
lordship.
no, even had there been evidence, the court could have formulated.
Yes. Non-formulation of issue is something else. Parties notes to the case, adduced evidence made in the pleadings, but no issues are formulated, does not vitiate the judgment. The court has ample power to reframe the issue.
Yes, well, questions of law can be formulated to
Here
now itself
also,
also.
provided issue raised and
It was decided.
decided. And this is the 2025 Supreme Court, my lord. The
No, you will give me all this, you give, but after all, you have to give it.
I make a
to give it
compilation.
compilation
Yes,
with
yes,
your written
certainly.
notes.
I've already prepared my written notes on the next day. It is already prepared.
Written
I've
notes,
already,
compilation and list of
yes,
dates.
yes,
Both of you.
as your lordship. And this is, my lord, reported in 2025 Supremacy 1077, where it is said what is required for 2025 Supremacy 1077.
Yes.
If your lordship am fine,
This is with regard to, okay, eviction notice.
what is followed by your lordship? What is precisely to what extent a landlord required to prove and how the owner shifts and when? Considering all other judges, my lord, this is
Yes, you see, service under NI Act and service of eviction notice, both are different.
that is what precisely what. My lord, the civil cases are considered on the preponderance of probability. And my lord, the criminal cases are considered on the basis of strict.
Yes, yes, strict proof.
So, putting the cross-examination, no question was put forward, my lord. Precisely what amounts to admission in the carpet case. It says that if it is a valid question which is in your hand, the person who have endorsed or tendered the notice, you did put this question to him. It amounts to that admission that it was tendered to you and it was refused by you. This is the admission under the carpets case.
So let them reply on the next day along with the written notes.
Yes, well, I can record that I have completed.
Yes.
No.
Yeah,
Yes.
Actually,
Learned advocates for the parties are present. Yes, yes, yes. Mr. Roy has concluded his submissions.
জানি রে আছে দেওয়া আছে
Let-
আমাদের কাছে কপি ছিল আমরা দিয়ে দিই কোনটা কোনটা 1980
27/1/2026 এই এক মিনিট দেখুন তো 27 তারিখে
Seven, 27 January. 27 January.
Yes.
Huh? Okay, 27/1/2026 at 4 p.m.
Lordship.
Huh? 3 সময় হবে? Okay, 3 p.m.
Lordship, 2 p.m. because 3:30 there's another matter fix. That is why.
Half an hour only reply and written notes.
compilation
3 p.m.
27/1/2026 to submit the reply by the appellant and for filing the written notes of arguments. Give the reply and file it on that day itself, written notes.
At 3 p.m.
Yes.
3 p.m.
Yes, Aki.
Item number 6, my lord, is the assigned matter.
Tomorrow, come tomorrow, I shall see. Both parties are present, I shall take
No,
it.
difficulty is, may I submit? Difficulty is, other side will not be available. The matter was earlier taken by my lord Justice Prosenjit Mishra, wherein my lord was pleased to release on personal ground. Now my lord is appearing for the first time. I have to serve notice upon the other side because it is also a change. Substitution application taken place. That time service was made. No one appeared. If my lord kindly passes an order, I have to serve the other inform other side.
এটা কি not today করেছে কি? ও কি মানে পিটিশনে অ্যাপেলেন্টের
I will appellate.
অ্যাপেলেন্টের হয়ে নট টুডে হয়েছে, তো উনি আছেন তো এখন, ও কেউই ছিল না, আচ্ছা যাকে অর্ডারটা একটা রেখে দিন। ওকে আচ্ছা, লেট ইট অ্যাপিয়ার টুমরো অ্যাজ টু বি মেনশন, কালকে টু বি মেনশনটা দিয়ে দিন। হ্যাঁ হ্যাঁ।
But tomorrow there is certain difficulty. That is why I. If
No, just in the first half, within half an hour it will be taken up. That direction.
Kindly takes it on Monday itself.
আচ্ছা, not this week করে দিন তাহলে।
My lord, item number 38.
Yes.
I am for the appellant.
Yes.
Interim order is expiring today.
38.
Kindly extend it. I have served the notice to the opposite parties. Advocate of the opposite party.
No, 38 can one. No, respondent has appeared.
I have served the notice twice.
Interim order is to expire today.
Yeah, my lord. Yes, my lord.
আচ্ছা, এটাকে কালকে টু বি মেনশনে দিয়ে দেবেন তো, আইটেম 38 টাকে।
Sir, kalke tomorrow.
No, in the first half itself, to be mentioned.
May I get the copy of the deposition?
Thank you, my lord.
Yes. Give it by way of compilation.
Yes. That's why, my lord, I have no copy.